Huh? Why? Huh? What is that extreme urgency?
Like we should do a notification for declaring the private land.
Remove it today. It will come out tomorrow. Yes. You can't move the memo like this, sir. You'll have to move it online. Let's move it online. Yes. No, unless they are there. Right. Who's on the other side? You take. It's a date given matter. Huh? Who is asking for adjournment? At the request of learned counsel for respond number 6. Release this matter on 17th of January 2024. Stop. Interim order granted earlier stands extended till next date. Or wakalat idea? Huh? Her office is directed to show the name of
Manasa B. Rao.
Manasa B. Rao for respond number 6. Since learned counsel Sri G.L. Vishwanath has been designated senior counsel. Yes. Send ಮಾಡಬೇಕಾ? Move ಮಾಡ್ತಾರೆ. I don't know whether that also can be moved. You have to move it online. You have to move it online. Okay. No, Rajan. Yes. Yes. To complete the recovery process.
Despite the receipt of the notice, they were replied and have not initiated any action against the judgment. that the recovery certificate was issued on 27/7/2020. Legal notice was issued to them on 27/10/2023. Notice was received by them on 28/10/2023. No reply in action.
High Court is to execute the order of the authorities. Why?
Because they are failed to act. These are legal.
Sir, the question is whether the authority has got the power to execute its order or not. If it has got the power, then you'll have to go before the authority.
There are authorities.
Yes.
Huh? That is my house. There are authorities. Does not powers. Into the RERA Act says, my lord, section 40 of the RERA Act. Recovery.
How can it be that the High Court will be executing the orders of the then?
Direction.
No.
A similar order was passed by this honorable court, which my lord.
Sir, that is not the issue, sir. I am putting a question, so we'll have to answer that. Yes.
Under section 40 of the RERA Act. Recovery
Yes.
of interest, penalty, compensation or enforcement. If a promoter or a minority or a real estate agent, as the case may be, fails to pay any interest or penalty or compensation imposed on him by the educating officer or the regulatory authority or the accredited authority, as the case may be, under this act or the rules and regulations made therein, it shall be recoverable from such promoter
Yes.
or minority or real estate agent
Yes.
in manner as may be prescribed as an earlier of manner.
Yes.
Subsequent, my lord, this is the act. The rules are rule number 25, my lord. It reads as manner of recovery of interest, penalty and compensation. Subject to provision of section 1 or section 14, the recovery of the amount due as arrear of land revenue shall be carried out in the manner provided in Karnataka Land Revenue Act 1960. Now, under Karnataka Land Revenue Act, section 160, an arrear of land revenue after serving a written notice of demand on the deposit.
Sir, you are not trying to understand the question of the court. There is the power vested with the authority. Is there a power? Then it cannot be that the powers are given and there is no power for execution. There has to be some authority which has to execute the order. Huh? No. It is not as simple as you are trying to make it out. It's impossible. No. Procedure is right, sir. In any number of statutes, this is the procedure. If a penalty is imposed and it is not paid, it shall be recovered as if it is a land arrear. That is, this kind of a provision is there in any number of acts, but that doesn't mean the deputy commissioner has to initiate the proceedings. You will have to point out from the provision of the statute itself.
So, as per 161 of the act, it says an arrear of land revenue may, after serving a written notice of demand on the defaulter. Now, the defaulters are also parties.
Such powers are vested with the authority itself. That is what you read out just now.
Not
The one that you read out just now is the power vesting authority in the authority. It has got the authority to recover as if it's an arrears of land revenue.
first.
It is impossible that the High Court will be executing the orders of the authority, sir.
Prayer is not that. My prayer is seeking a direction. My prayer is that page number
Barkale.
18. My lord. Issue a writ.
The petitioner is seeking a direction to the revenue authorities, more particularly the Tahsildar or the deputy commissioner, for executing the orders passed by the Karnataka Real Estate Regulatory Authority under the provisions of the Real Estate Practical Regulation and Development Clause Act number 2016. Stop. A question has been posed to the learned counsel for petitioner as to whether the High Court can become an executing court for the orders passed by the authority. Stop. Learned counsel for the petitioner is required to answer this question. Full stop. Next para. The learned HCGP is directed to take notice on behalf of response number 1 to 4. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned HCGP. Stop. Release this matter on 17th of January 2024 to enable the learned counsel for the petitioner to satisfy this court regarding the query post. You know, find out. No, not yet.
So, even next month.
Application in form number 53 is not yet on. Application in form number 53 is not yet considered. Committee is constituted. And hence, we are seeking a written nature of mandate. The application to be placed.
ಯಾವ ಊರು?
KR-8.
KR-ಪೇಟೆ. What do you say? Will you dispose of the matter or will you take instructions? Learned HCGP takes notice for all the respondents. Correct. The grievance of the petitioner is that his application filed in form number 53 on 31/3/1999 seeking regularization of unauthorized occupation of 2 acres of land in survey number 69 of Pura village, Kasaba Hobli, KR-Pete Taluk, Mandya district has not been disposed of by respondents number 4 and 5. And therefore, the petitioner is seeking a writ of mandamus directing the authorities to consider and dispose of the application within a time frame. Stop. Next para. Learned HCGP submits that the fourth respondent Tahsildar will verify from the records as to whether such an application has been filed by the petitioner, and if so, the application will be considered and disposed of within a time frame fixed by this court. Stop. Next para. Consequently, the writ petition stands disposed of with a specific direction to the fourth respondent Tahsildar, KR-Pete Taluk, to verify from the records as to whether such an application has been indeed filed by the petitioner, and if such application is filed and if it is not disposed of, then the Tahsildar shall place the application along with his recommendation before the fifth respondent committee within a period of 2 months from the date of receipt of a copy of this order. Stop. The fifth respondent committee shall thereafter consider the application in accordance with law and pass orders as expeditiously as possible, and at any rate within a period of 2 months from the date when which the application is placed by the Tahsildar before the committee. Stop, ordered accordingly.
Endorsement connection G method is called in question. The representation of the petitioner was, he had got 1 acre 21 quintals of land converted into residential and for the purpose of running a dairy. In survey number 69. Now the dairy unit was no more functional, and hence he wanted to convert the other land, piece of land also to the residential purpose. Application was given and the Tahsildar conducted the spot inspection. The Tahsildar and the Urban Development Authority both recommended for conversion of the land, in view of the fact that the neighboring land holdings have all been converted into residential purpose. But by issuing the improved endorsement, the Deputy Commissioner has rejected my application, stating that 1 acre 21 quintals of land was sought to be converted earlier. But which portion of the land was residential, which was for the dairy, was not designated in that order. And hence it cannot be done, is what we says. But the report, in annexion E, the Tahsildar has given in the form of a recommendation. He has designated, where the portion of the land is now remaining vacant, and has specifically recommended that it has got the road access also. That was positively considered, has been granted. But only on that premise, the endorsement. The Tahsildar and Urban Development Authority have positively recommended for that.
Learned HCGP takes notice for response number 1 to 4. Issue notice to respond number 5. Learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures on the learned HCGP. Stop. Next para. Learned HCGP is directed to secure instructions for the second respondent, Deputy Commissioner, as to why the endorsement has been issued by the additional Deputy Commissioner on 6/12/2022, declining to consider the application filed by the petitioner for already 1 acre 21 guntas alli 32 guntas were converted for residential purpose.
Yes, sir.
Mikiddu
Dairy purpose.
Huh?
Running a dairy.
Converted. Then
What happened to the dairy purpose was.
then it is only a question of a change of land use then. Where is the question of conversion?
Dairy was.
Correct, sir. It is only a change of land use from dairy purpose to residential purpose, which has to be considered by the fifth respondent. There is no question of conversion once again. Conversion is under section 97 from agricultural to any other purpose. That is already done. So if you want a change of land use, then you have to approach the fifth respondent.
Fifth respondent to connection here. Has given no objection. And he has said,
No, not the question of no objection. See, there is a comprehensive development plan. And now, by virtue of the conversion order, you had sought for conversion for dairy purposes, and it was converted. And the authority approved the layout for resident purpose and dairy purpose. Now you want to make use of that area which was converted for dairy purpose into residential purpose. For that purpose, you need not have to file one more application under 97. ಬರೋದಿಲ್ಲ.
Next year, yes, if my lord, I may trouble my lord, next year, yeah. Now, the urban development authority makes a communication to the deputy commissioner. And says, I follow my lord.
Yes.
Now, the difficulty is the urban development authority.
Now it will be under the urban development, sorry, Town and Country Planning Act, section 14.
Yes, sir.
14, you will have to make an application to the fifth respondent authority seeking change of land use. There is no question of conversion again.
Right, see that. Take notice, my lord, so that the urban development authority makes it.
What application did you make before the fifth respondent?
So, sir, I made the application only before the deputy commissioner.
ಅದೇ ತಪ್ಪಾಗಿದೆ.
Deputy commissioner said it to the urban development authority.
Then we will clarify. We'll clarify the position and we will say there was no need for you to file an application under 97 because the land is already converted. All you have to seek is a change of land use and you can go before the fifth respondent authority. ತೆಗೆದಾಕ್ಬಿಡಮ್ಮ. ಹಂಗಾದ್ರೆ let this the fifth respondent be served and some learned counsel come on record, you will see. The petitioner is also permitted to take out hand summons to respond number 5. Release this matter on 23rd of January.
And in question is the now land, the grandmother of the petitioner was. Father has continued.
1981 order you are challenging now. Huh?
Individual notice issue. Issue. Even though the ROR shows the name of the father of the petitioner, there was no such. Now the petitioner or grandmother has not made any formal or one grant of confirmation of occupancy rights. But now here the Karnataka government has extended the time for filing of the application. Produce collection J is the notification. As per which measure the petitioner has made an application for confirmation of occupancy rights. That application is pending. But now this order next year will come in the way of consideration of that next application.
Annexure G na.
Annexure J is the notification. Exact notification. Get it 48. Number 48. Amendment of Karnataka Act 10 of 1978. In section 11 of the Karnataka Section Minimum Population Act 1977. Karnataka Act 10 of 78. In subsection 1 and in the proviso here and there. For the words, figures and letters on or before 31st day of March 1991. The words, figures and brackets within 1 year from the date of commencement of the Karnataka Section Minimum Population and Amendment Act 2007. Earlier, the cutoff date was ended on 31st March 1991. Now it is extended up to 1 year.
ಅದು ಆಗೋಗಿದೆ.
It was filed on 27/5/2022. It's a K in the other.
ಏನ್ರಿ ಇದು Annexure J na.
Section K is the application for registration of. Next, sir, J. Millard was gazetted on 18th January 2022.
Hmm.
From that day onwards, sir, so 1 year time was granted.
Hmm.
Now the application is filed on 27/5/2022.
Hmm.
Within that.
Hmm.
Now this application has to be considered.
Hmm.
And in order to consider, since this application, when this annexed A will come into effect.
Hmm.
Because in which manner the land was registered in the name of the temple on the request of the Tahsil.
Correct. Hmm. So therefore, just because a provision is now made, can that be a ground for you to challenge this order which was passed in the year 1981? What is the explanation you offered for delay?
These manner that. Another thing is that even though the records of rights shows the name of the grandmother.
Learned AGA, learned HCGP takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned HCGP. Full stop. Next para. The respondent state and the revenue authorities are directed to file statement of objections within a period of 4 weeks from today. Yes.
Number one to an extent of 2 acres in shoreline area of statement of grant in 1952. The producer RTC extracts from 1965 to 1990. 1992, the property condition, the BBMP description, the BBMP attached record for this property. And the entries continued it as such, even as of today, the BBMP is standing. The respondent number 6 and 7, the defense department gives a representation saying that this is part of their property. If this is the representation is given to the Tahsildar. Tahsildar writes a report to the Deputy Commissioner on 3/2/2011 saying that the entries requires to be ascertained. So there is a slow amount of proceedings initiated by the Deputy Commissioner. And the Deputy Commissioner passes an order on 16/6/2014, which are article find page number 990. They request your notice by kindly take page 98. Respondent numbers 6 and 7 in the present petition are shown as respondents 2 and 3 in the revision petition, that's 136 proceedings. Operative question is at page 98. Since these matters were not being considered, there was a repetition filed, there was a direction that it should be considered expeditiously, and what referred to operative question. In compliance of the directions of the honorable activity WP number so now, wherein I have been directed to dispose of 160 cases before 30th April 2014. And accordingly, proceeding the present case conclude as per law with an observation that the entries of the names of Ardan in the record, in the records with RTC and MR, and are even though made under the provisions of 127/1928, prescribed after effecting the mutation, beneficiary appears to have not modified or given written information to second third. For all the reasons, we believe that their interest in the land covered the mutation entry. For this reason, it would satisfy the complaints of 126 to 159. In view of the observation made in the honorable activity in WP number so. For reason that 126.3 provides only limited power of correction of entries and not for cancellation of entries in the revenue records. It is open to the respondents RTO and RP who have a parallel claim of title and possession of the subject land to resort to the proviso to section 130 of the KLR Act for declaration of the title of the subject land, and by then can also challenge the present BBMP orders between the appropriate appeal authorities of BBMP. Scope available for the purpose declared contrary to 126 feet may claim the judgment. Then para 5. Keeping in view the above judgment in WP number so the Tahsildar not public is directed to initiate separate inquiry under the relevant land grant legislation prevailing of the period in order to look into all the aspects of the grant by giving a notice to option to R1 to R2 to represent producing documents in their hand. Tahsildar to go thoroughly examine all available revenue documents related to the grant of lands to R1 in respect of the subject land, not to find out whether there are any procedural lapses or ineligibility of the grant to get a grant or grant is obtained by fraudulent method or whether there is no grant at all, and finally to take necessary action as provided in the law. This is the operating portion. So far as the grant and the revenue records are concerned, the matter is delegated to the Tahsildar to conduct the inspection. So far as their client is concerned, they said that you have to work out your remedies in the civil. These were the two things which was observed. But the matter went to the Tahsildar. The Tahsildar had passed an order on 13/7/2015 stating that the grant is genuine, the revenue, that is the Sagori chit register extract is available, Darkar register is available, mutation is available, index of lands is available, everything is available from 1954 till date with all the tipnees and all. Therefore, the grant is genuine and the entries are genuine. This was the report of the Tahsildar. But respondent 6 and 7 file an appeal before the assistant commissioner, which your losses will find notes at page number 100. Next page itself. This is the notice which was issued. Because page number 101 is the appeal copy which is filed by them. In the year 2016-17. This appeal is still pending consideration before the assistant commissioner. Now, there is another parallel proceeding which the deputy commissioner initiates under 136D if your losses was to take page 117, which is the order included before your losses. But in this, at page number 122, second paragraph, goes up to the first paragraph, which is the content. Second paragraph and onwards, he records a question of title as being vested to the respondent 6 and 7. By considering the material documents available on record, mostly the documents released by the response to entry shows. Landing question forms part of survey number 7 line. Said land has been acquired by the proceedings conducted by the government of the science, knowledge of Mysore, Paragraph number 95. Legal statement law, the question number one, claim under references to be answered in the affirmative, voting that the state is authorized to enact the law. And the entries in list 2 of challenge should be in the background of the constitutional mandate under Article 246 of the Constitution of India and not traverse beyond authorized field of legislation set out in 1845. Entry 65 is not applicable with regard to revenue matters. Accordingly, question number 2 has to be answered in the negative voting that revenue officials in the rank of Assistant Commissioner, Appellate Authority, Deputy Commissioner, Judicial Authority, under provisions of 136(2) and 3 of the Karnataka Land Revenue Act cannot decide the dispute between the parties involving adjudication relating to title and possession, and they are authorized only to decide the entries based on the source of title.
It's a reiteration of the.
Of the earlier judgments.
But there is absolutely nothing. We don't understand why this proceedings have been initiated suo motu.
This is the reason why it said. 136 has been initiated against respondents 2 and 3. Condition precedent to exercise the jurisdiction is that respondents 2 and 3 are having their names in the mutation entries. At no point of time there was a mutation entry in the name of respondents 2 and 3. It's highly mischievous.
Yes.
And was acquired very
Sir, you are not anything very special. If please listen. If you are aggrieved of any person encroaching upon your property, you will have to take recourse in a manner known to law. This is not the way. If someone has encroached on your property, is this the way to get the? Then yes. Why this kind of proceedings then? At whose behest?
Yes, sir. There are batch of petitions which have been initiated by petition as well as the family member. I have that full details. For 10 minutes, sir, I can demonstrate what are the actual facts, sir. We largely know exactly what the fraud played before the courts.
Sir, that is why I said that if any fraud has been played, if some other individual person is an unauthorized occupation of your property, you will have to take recourse in a manner known to law. This is not the way. Yes. What are you trying to say, sir? That they are in unauthorized occupation. Then what are you trying to say? Yes. Yes.
Must be the land measuring 373 acres.
Sir, we are not going into the merits of the matter. Please tell us what is that you want. Yes.
The land was earlier acquired for the benefit of the state.
Yes.
Once the land is acquired, question of any other person getting granted does not arise.
All right.
Because the referred in this order was filed for 18 acres of land forming part of the very same survey number, which was dismissed. When the order that is application was filed, that they filed rejected, it was came before this division by the court. Division went specifically directed to Tashina to file an affidavit. He filed an affidavit warning that these are the entries which are fabricated.
All right.
Afterwards, who was contested by the state was the party. State header is the their law. Not the person who are claiming. And who was rejected? They rejected. Now they have filed an appeal. Now what I am trying to say is, these proceedings not just one matter. There are more than 15, 20 such petitions are there. That came only at the base of persons who are within their group. I replace all medical record.
No, sir. The special deputy commissioner is saying the proceedings have been initiated suo motu.
Because they are the one who.
How? Where is the question of suo motu proceeding? If it is the contention of the state government that it is not a property belonging to the state government, where is the question of suo motu proceeding? So it can be at your instance or at the instance of some other person. So therefore, no, the special deputy commissioner, the deputy commissioner himself says it's a suo motu proceedings. Correct. There again it says suo motu proceedings. Yes.
And they are the one who went before the court and got the direction to them. These are all only multiple proceedings. Each time I place all matters, then anything can be possible. Because ramification of so many acres of land which which is not belonging to them, it's a fabricated.
Sir, we are not going into that question at all. This question simply is, how did the special deputy commissioner initiate this proceedings? That is all. And if you are saying, no, it was not at our instance, then we'll ask the special deputy commissioner, how did he initiate this proceeding? Not necessary, sir. It is not necessary. The only question, the contention of the petitioner is, it says suo motu proceedings. This is the second time. That is all. HCDP takes notice for response number 1 to 5. On the learned HCDP, full stop. Next para. Office is directed to show the name of learned counsel Sri M.N. Kumar for response number 6 and 7. Next para. The petitioner is aggrieved of the impugned order at annexure L dated 23/5/2023. Stop. Learned senior counsel Sri D.R. Ravishankar, appearing on behalf of the petitioner, submits that although a suo motu proceedings were initiated by the special deputy commissioner, Bangalore North in RRT bracket 2 close N another bracket A close bar CR bar 28 bar 10-11 and orders were passed on 19th of June 2014. While directing the Tahsildar North Taluk to initiate separate inquiry under relevant land grant legislation prevailing at the relevant point of time, in order to look into all aspects of grant while giving opportunity of hearing to the parties herein, contesting parties herein, and thereafter consider whether the claim made by the petitioner herein is fraudulent or genuine. Full stop. Learned senior counsel submits that it is impermissible in law for the special deputy commissioner to once again initiate proceedings invoking suo motu powers under section 136 bracket 3 of the Act.
The second order passed in the same file, same number.
Or same number.
Same number.
Although it appears that the proceedings have been once again reopened in the same proceedings and orders are passed inconclusively, but which may affect the right, title and interest of the petitioner. Stop. The next para. The learned HCGP is therefore directed to secure instructions from the special deputy commissioner, from the third respondent, special deputy commissioner, Bangalore North Division, as to how and under what powers did the special deputy commissioner initiate the proceedings and pass the impugned order? Full stop. If necessary, statement of objections shall be filed within a period of 2 weeks from today. Full stop. Release this matter on 30th of January 2024. ಏನ್ entry ಏನ್ entry ಮಾಡು?
Therefore, as much as we have to take here that even the proceedings before the assistant commissioner declares to the state, this order is more than sufficient to allow their appeal before the assistant commissioner. Appeal filed by us. Now, the finding of fact is given that they are the guided orders by the deputy commissioner. What will the assistant commissioner do?
ಇನ್ನೊಂದು ಪರ ಸೇರಿಸ್ಕೊಳ್ಳಿ. If any proceedings are pending before the assistant commissioner, Bangalore North Division at the instance of the contesting respondents here, the assistant commissioner shall not be prejudiced by the impugned order.
Pending question matter for polarized by the committee of as per annexure B, we had referred conducting a survey and they have collected TP by also. They have been issued arguably fixed in respect of that portion, they have not issued. I have filed a representation. They have not considered and I have approached this honorable court.
Endorsement issue ಮಾಡಿದಾರ?
As per annexure G, has directed the Tahsildar to consider the representation and Tahsildar has issued an endorsement stating two fold. One is that the Tumkur has become a Mahanagara Palike and the jurisdiction is extended to up to 10 kilometers. The another thing is that the order of the land committee is not yet confirmed. On 240 endorsement issue. But as it is that the Tumkur has become Mahanagara Palike.
ಅದಾಯ್ತು. It will be contrary to the provisions which falls within the prohibited distance. One, but it does not deny the fact that the committee had passed an order. Huh? ಎರಡ್ ಸಾವಿರದ ಎರಡು ಮಂಜೂರಾಗಿದ್ದು. So it will be covered under that order that has been passed by me. See, here is a case where the committee has already decided in the year 2002 itself. Yes. Correct. Alli those applications were still not considered. Here is a case where considered and order has been passed in the year 2002. ಏನ್ ತೀರ್ಮಾನ ತಗೋಬೇಕು? ಏನ್ ತೀರ್ಮಾನ ತಗೋಬೇಕು ಅಂತ? ಯಾವ ಸಮಿತಿ? Why? That committee has already decided in the year 2002 itself. Why it is not implemented? 2002 ಅಲ್ಲಿ when it was considered, there was no difficulty. then the Tahsildar should have challenged that order. Madilvala, it was not done. Where is the occasion now to reconsider? Baradilla. No. Not permissible. It clearly goes against the law laid down by this court. Yes. No. No. The statements that he has made in the endorsement will go against the orders passed by this court. ಅವಾಗಲೇ ಮಾಡಬೇಕಾಗಿತ್ತು. Why did you not do? Therefore, there was a direction by the court, by this court, by order dated 22nd of July 2022. He has also remitted the requisite sum. Then learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Full stop. Next para. It is the contention of the petitioner that despite the observation of this court in its order dated 22nd of July 2022, passed in WP number 6151 of 2022, that the respondents cannot deny the fact that the committee has considered the application filed by the petitioner and passed an order recommending grant in favor of the petitioner, and consequently the petitioner remitted the requisite amount towards the grant and further directed the second respondent, Tahsildar, Tumkur Taluk, to consider the request made by the petitioner for issuance of Sagoli sheet. The Tahsildar has only issued the impugned endorsement dated 8/8/2023 at annexure F. Stop. Next para. On going through the impugned endorsement, this court finds that the Tahsildar does not dispute the fact that the committee passed an order on 14/8/2002 recommending grant of 1 acre and 10 guntas of land in survey number 19, in survey number 7 of Basavapattana village in favor of the petitioner. Stop. The other observation that now the land falls within the prohibited distance of 10 kilometers from the boundary of the Tumkur Mahanagara Palike, will go contrary to the law laid down by this court in WP number 2411 of 2022, dated 18th of February 2022. Stop. At this juncture, learned AGA seeks for a short accommodation to secure instructions and make submissions. Stop. Release this matter on 22nd of January. Application filed in the year 98. Ah. Ah.
Not consider. The part of my lord, the decision or approval of some court, page number 20.
Ah.
During the some court in the initial granted the instance. Thereafter, the matter listed 30th October 23, annexed G.
Ah.
The some court once again directed me to give the representation aspect of letter on the section. Rule 108 and also section 94 JFT. Karnataka Land Board. Immediately remember the additional gave representation to the DC, JC, as the law. And we will sort of. But now, after that, now we responded according to the remote. Trying to vacate me from the middle problem. Maybe to the election email, the adjacent land will go get. Or grant money or then the artist put in the election email to the one. ಪಕ್ಕ ಜಮೀನು ಇಸ್ಕೊಂಡು ನನಗೆ ಇಬ್ಬರು 98 ಇಬ್ಬರು ಆಗ 30 ವರ್ಷದಿಂದ ಸ್ವಾಧೀನ ಖಾತೆ ಎಲ್ಲ ಕೊಟ್ಟಿರೋ ಅರ್ಜಿ ಎಲ್ಲ ಕೊಟ್ಟಿರೋ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ ದಿಸ್ ವಿಲ್ ಮೈ ಲಾಟ್
ಯಾವುದು ರಾಮನಗರನಾ?
ರಾಮನಗರ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ತಾಲೂಕು ಈ ಹೊಸಳ್ಳಿ ವಿಲೇಜ್ ಮಲ್ಲಾವಡಿ ಹೋಗ್ಲಿ ಕನಕಪುರ ತಾಲೂಕು ರಾಮನಗರ ಡಿಸ್ಟ್ರಿಕ್ಟ್.
Yes. Yen ಮಾಡೋಣ? Allah, see, application itself is not considered still, while the application of others are considered. So there was no need for giving one more representation. All you had to do was to find out whether the application was filed by the petitioner. If it is found that it is filed, and then you will have to answer why it was not disposed of. Otherwise, if it was disposed of, it was simply given an endorsement stating it was already disposed of by order dated so and so. There is no scope for making any other contention. Berkeley. Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Stop. Next para. It is the contention of the petitioner that his application for regularization of unauthorized occupation of 1 acre of land in survey number 12 of T. Hosadli village, Maralavadi Hobli, Kanakapura Taluk, Ramnagara district. Has not been disposed of till date. Full stop. Earlier, the petitioner had approached this court and there was a direction issued by this court in WP number 3979 of 2023, dated 30th of October 2023, enabling the petitioner to give one more representation to the competent authority. And accordingly, the petitioner has given several representations thereafter. Full stop. However, instead of considering the application, efforts are now being made to evict the petitioner from the land in question. Full stop. Next para. Consequently, the respondents authorities are hereby directed not to take any action in respect of the land in question for eviction of the petitioner. Stop. The learned AGA is directed to secure instructions from the fourth respondent Tahsildar to who shall verify the records and state as to whether such an application was indeed filed by the petitioner on 10/11/1998, and if so, whether such an application, whether the application was disposed of by the committee or not. We'll stop. Release this matter on 24th of January.
Direction to consider their resignation. It seems to for issuing voting, durability, and
Same yesterday, same order. Online application ಕೊಡಬೇಕು ಅಂತ. Nine not same. Same order. Learned AGA takes notice for all the respondents. Lastly, 4 weeks for filing memo of appearance. Notice at annexure A. ಏನಂತ? Against whom? What is the allegation?
So, non-property encroach majority from the road, it is available for the responsibility to access this property. If purchase the property immediately to so purchase money, we approach me for sell my property to leave to form the layout for me. I refuse because I not accept this property. I have no property for doing agriculture work. The my family is depending on the agriculture income only. When I refuse my land, I will disturbing me. So on these 2023 company with the Rajapal saying that these insurance is disturbing me to use the loan matter. After receiving the complaint, immediately start and conducting the survey and the report matter. In the report is very clearly stated that there is already the public way is available. Road is available for the one tank is there. But that use that road matter. If it is use that matter, now responding only with each other. They want to make a road in the middle of the agricultural land.
Learned AGA takes notice for respondent number 1. Issue notice to respondent number 2. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Stop. Next para. Learned counsel for the petitioner submits that at the instance of respondent number 2, the impugned notice at annexure A dated 27/12/2023 has been issued by the first respondent Tahsildar, Piriyapatna Taluk. Full stop. It is submitted that the second respondent purchased the neighboring property in the year 2021, and thereafter he is pressurizing the petitioner to dispose of the property belonging to the petitioner to enable the second respondent to form a road and have an access to his property. Stop. When the petitioner denied, the second respondent has prevailed over the first respondent Tahsildar, who has issued the impugned notice making unfounded statements. Stop. The petitioner contends that he has not encroached upon any portion of the land belonging to any person or any road. Full stop. Next para. In that view of the matter, the first respondent, Tahsildar, is required to furnish information to show that in the village map, there was a road existing on the property belonging to the petitioner. Stop. Next para. Till the disposal of the writ petition, the respondents are directed not to precipitate the matter and not to do anything further consequent to the impugned notice dated 27/12/2023 at Annexure A.
Suresh Babu, BM.
Huh? Huh? Why? ಅದಾಗ್ಲಿಮ್ಮ ಇದನ್ನಾದ್ರೆ ಸೇಮ್ ಆರ್ಡರ್ಸ್ ವಿಲ್ ಬಿ ಪಾಸ್ಡ್. At the request of learned counsel for petitioner, release this matter on 18th of January 2024. Which are the other matters? Writ petitions number so and so, also filed by the learned counsel, may be listed along with these matters. Third. You are asking for Lebanese sketch. Annexure HR. Lebanese sketch will not be prepared by the Tahsildar. ADLR. ಹಂಗಾಗೋದಿಲ್ಲ. ಬರೀ 11 sketch ಖಾತಾ. What is your a claim to the property? How? On what basis? Registered partition deed.
There is no dispute regarding that. There are opposite parties also admit. Observation given in RRT proceeding relates to the page number 20.
1993. Who are the other parties? They have not been made parties here.
35 minutes. 35. Again, the petitioner's mother approved the report and got election. On the basis of that, petitioner mother's name got entered into notation. And now minutes is more. So minutes earlier petitioner, our mother is a petitioner. Is now given up.
So it is not on the basis of partition then. It is only on account of the death of the Khatedar. Re adayt re. On the basis of that partition, your mother's name has been entered. Now you are saying your mother passed away and therefore the names of the legal heirs have to be entered. Is that the position? ಹಾ.
page 27.
ಹ್ಮ್.
of the, it takes discussion of her name as well as its other inheritance part of the it is in respect of subject land.
ಹ್ಮ್.
It is written into file with the mother.
ಹ್ಮ್. Correct. No, no, no. On the basis of this direction, her name has been entered. Now she is no more. ಪೌತಿ ವಾರಸು ಕೇಳ್ತಾ ಇದಾರೆ ಈಗ. ಪೌತಿ ಖಾತೆ ಮಾಡೋದು ಕೇಳ್ತಾ ಇದಾರೆ ಅಷ್ಟೇ ಸರ್. ವಾಟ್ ಇಸ್ ದ ಡಿಫಿಕಲ್ಟಿ? ಆಯ್ತು, ಅದು ಇರ್ಬೋದು. ಇಟ್ ಈಸ್ ಎ ಫ್ಯಾಕ್ಟ್ ದಟ್ mother's name is entered. Now she is no more. Children have given a representation now. We are the legal heirs, enter our name anta. Why should they not consider? 11 sketch ಏನಕ್ಕೆ ಬೇಕು ಅದಕ್ಕೆ? ನೀವು ಮತ್ತೆ ಫರ್ದರ್ ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ? ಯಾವ್ದಕ್ಕೆ? ರೀ 11 sketch ಅಂದ್ರೆ ಅರ್ಥ ಗೊತ್ತಾ ನಿಮ್ಗೆ? ಒಂದು ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಮಧ್ಯಾಹ್ನ ಮತ್ತೆ ಭಾಗ ಮಾಡ್ತಾ ಇದ್ರೆ ಯಾವ ತರ ಭಾಗ ಮಾಡ್ತಾ ಇದೀರಾ ಅಂತ ತೋರ್ಸೋದಕ್ಕೆ 11 sketch. ಯಾರ ಮಕ್ಕಳ ಮಧ್ಯೆ? ಯಾರ ಮಕ್ಕಳ ಮಧ್ಯೆ? ಹಾ, ಹೆಂಗಾಯ್ತು ಡಿವಿಷನ್? ಅದರಿ, so therefore the names will be jointly entered. Otherwise there has to be a partition to show which portion is falling to your share, which portion is falling to the other person. Only then the question of making a 11 sketch would come. Unnecessarily you are complicating the issues. Learned AG takes notice for the respondent. Tahsildar, Devanhalli Taluk. We'll stop. Next para. It is the grievance of the petitioner that the respondent Tahsildar has not passed any orders pursuant to the representation dated 14/12/2023 given by the petitioner. Where I have stated that your mother's name was entered. Thereafter she passed away. Representation will read. ನಾರಾಯಣಮ್ಮ ಮತ್ತೆ ವೆಂಕಟಮ್ಮ. ನಾರಾಯಣಮ್ಮ ಮತ್ತೆ ವೆಂಕಟಮ್ಮ. ಹೂ ಇಸ್ ವೆಂಕಟಮ್ಮ? ಹ್ಮ್. 30/10/2023 ಮರಣ ಹೊಂದಿರುತ್ತಾರೆ. ಆರು ಜನ ಮಕ್ಕಳಿದ್ದು ಸೋನ್ಸು. Where is the RTC? Latest RTC? Narayanam.
Page number 58 is Narayan.
3 acres, 22 guntas. ಎರಡು ಒಂದೇ RTC, 2 ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ. ಅಲ್ವಾ? So out of this 3 acres, 22 guntas. It is not known as to what is the rights that have fallen into the share of Venkatama and Narayanama separately. So it is jointly. And we can only ask them to show your name instead of Narayanam. Aste. Further partition agidre matra, you will have to go and give the document along with Leveni sketch. Otherwise, it is not possible. It is the contention of the petitioner that consequent to the directions issued by this court, the respondent Tahsildar entered the name of Srimati Narayanamma, the mother of the petitioner, along with Srimati Venkatamma in the RTC in respect of survey number 110. of Tindlu village, Kundana Hobli, Devanalli Taluk. Full stop. Attention of this court is drawn to the latest RTCs at annexures F3 of the year 2022-23-24, which reflects the name of Srimati Venkatamma and Srimati Narayanamma in respect of 3 acres and 22 guntas of land in survey number 110. Full stop. However, after the death of Srimati Narayanamma, who passed away on 30/10/2023, the petitioner has given the representation at annexure H dated 14/12/2023, seeking mutation entry of the names of all the 6 children of Srimati Narayanam in the place of Srimati Narayanam. Full stop. Next para. Having been satisfied with the material available on record, this writ petition stands disposed of with a direction to the respondent Tahsildar, Devanalli Taluk, to consider and dispose of the representation dated 14/12/2023 given by the petitioner for entering the name of the legal heirs of Srimati Narayanam in the land records in respect of survey number so and so, measuring 3 acres and 22 guntas, along with Srimati Venkatam. So the entire exercise shall be completed as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order, ordered accordingly. All right, office objection is over.
first, second respondent. Because the note was issued on 7/2020. I appeared before the second respondent and.
L and M. L is passed by the assistant commissioner. Cancelling the grant,
Also, was
grant was made on
92. 92, 92.
82, 92.
That is what issued. After inheritance, I have offered. Was before the first respondent, but there was not one sufficient opportunity. Only reason is like sufficient opportunity provided to depending matter before the second respondent.
Please read the unnumbered third paragraph in page number 31. ವಾದಿ ಪ್ರತಿವಾದಿಗಳ ಹೇಳಿಕೆ.
ಜಮೀನಿನ ಖಾತೆ ದಾಖಲಾಗಿರುತ್ತದೆ. MR ನಂಬರ್ 5/2012 ಸ್ವಾಮಿಗಳು 2 ಎಕರೆ ಜಮೀನಿನ ಖಾತೆ ಹೊಂದಿದ್ದಾರೆ. ಜೈನ್ ಅವರಿಗೆ 4/8/2012 LND SR 210 ದರಖಾಸ್ತು ಮೂಲಕ ಮಂಜೂರಾಗಿರುವ ಸಾಗುವಳಿ ಚೀಟಿಗಳು ಕೃತಿಗಳನ್ನು ಅರ್ಜಿ ಸಲ್ಲಿಸುವುದು ಸರಿಯುತ್ತೆ. ಅದರಂತೆ ತಲುಪಿಸಿದ ದರಖಾಸ್ತು ಮಂಜೂರು ಸಮಿತಿ ಸಭಾಂಗಣದಲ್ಲಿ ಭೇಟಿ ಆಗುವುದು. 98-99 ಸಾಲಿನ ದರಖಾಸ್ತು ಮಂಜೂರಾತಿ ಕಚೇರಿಗೆ ಸಭೆ ಹೊಸ ನಂಬರ್ ಸಾಲಿನಲ್ಲಿ ಆರೋಪ ಫಲಾನುಭವಿ ಸರ್ಕಾರಿ ಜಮೀನಿನಲ್ಲಿ ದುರಸ್ತಿ ಕಾಯ್ದೆಯಲ್ಲಿ
ಯಾರೊಬ್ಬ ಫಲಾನುಭವಿಯು ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಭೂ ಮಂಜೂರಾತಿ ಕಾಯ್ದೆಯಡಿಯಲ್ಲಿ ಬಗರ್ ಹುಕುಂ ಸಾಗುವಳಿ ಮಾಡಿಲ್ಲವೆಂದು ಬಗರ್ ಹುಕುಂ ಸಾಗುವಳಿ ಸಕ್ರಮೀಕರಣ ಸಮಿತಿಯು ತೀರ್ಮಾನಕ್ಕೆ ಬಂದು ಒಟ್ಟು ಓದಿ ವಜಾಕರಿಸುವುದರಿಂದ
ನೀವು ಕೇಳಿರುವ ಸಾಗುವಳಿ I was not provided an opportunity to due to 7/2020 I appeared before the second respondent. Later on due to lockdown I couldn't appear.
Already ಏನಿದು why is it proceedings initiated under rule 108K or what is this? The petitioner is Tahsildar. So it appears that it's a proceedings initiated under 108K. ಕ್ಯಾನ್ಸಲ್ ಮಾಡೋ ಪ್ರಶ್ನೆ ಎಲ್ಲಿ ಬರುತ್ತೆ? It is a fraudulent grant. ಇವ್ರು ಹೇಳ್ತಾರದು ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅನ್ಬಿಟ್ಟು. ಇವಾಗ ಓದಿದ್ರಲ್ಲ ಲಾಸ್ಟ್ ಫ್ಯೂ ಲೈನ್ಸ್ ಓದಿ. ಆಯ್ತು, ಇನ್ನು ಸ್ವಲ್ಪ ಕೆಳಗಡೆ ಬನ್ನಿ. ಗೊತ್ತಾಯ್ತು, ಪ್ಲೀಸ್ ಕಮ್ ಡೌನ್. ದಿ ಫೈಂಡಿಂಗ್ ಈಸ್ ಈ 98 210 1998 1999 ರಂತೆ ಇದೆಯಲ್ಲ, ಅದಾದ್ಮೇಲೆ ಓದಿ. ಸದರಿ ನೆರಳೂರು ಗ್ರಾಮದ
ಫಲಾನುಭವಿ ಸರ್ಕಾರಿ ಜಮೀನು ಭೂ ಮಂಜೂರಾತಿ ಕಾಯ್ದೆಯಲ್ಲಿ ಸಾಗುವಳಿ ಮಾಡಿಲ್ಲ ಸಾಗುವಳಿ ಸಕ್ರೀಕರಣ ತೀರ್ಮಾನಕ್ಕೆ ಒಟ್ಟು 19 ಅರ್ಜಿಗಳನ್ನು ದಿನಾಂಕ 17/7/2000
ವಜಾಕರಿಸಿರುವುದರಿಂದ
ಮಂಜೂರಾತಿ ಆಗಿಲ್ಲ ಅಂದ್ರೆ means what they are trying to say is that the document what they have given, that was not document. Your application was already rejected in the year 1998 ಅಂತ ಹೇಳ್ತಾರೆ.
Where is the question of initiating proceedings under 108K for cancellation of the grant?
But the document that you produce ಮಾಡಿರಲ್ಲ, doing that you have grant to enter my name in the application. You other than whether the land was granted to you or not.
ಏನ್ ಬರುತ್ತೆ? If the contention is that there was no grant and therefore there is no question of entering your name.
They have to give the document showing that it has been granted, enter our name in the article. So he verified and in there, he respect of.
That name was never entered.
That is the reason why proceedings was.
Then how can it be suo motu proceedings? It cannot be a proceedings under 108K. If they have given a representation to the Tahsildar asking for entry of the name in the land records, the Tahsildar should have issued an endorsement. Illa nimge yadu grant agilla, there is no question of entering your name in the land records. It was as simple as that. Where is the question of initiating proceedings under 108K? Alva, only if there is a requirement of cancellation of the grant, then proceedings under 108K will be initiated. If your contention is they were never granted and their names were not entered, and application is now made by this person seeking to enter the name of his whoever was granted the land, a simple endorsement could have been issued by the Tahsildar. Where is the grant? There is no grant and therefore your name cannot be entered anta. And he is saying it's a suo motu proceedings. The petitioner is shown as Tahsildar. Allah, the previous sentence, if you continue to read, ಪ್ರಯುಕ್ತ ನೀವು ಕೇಳಿರುವ ಸಾಗುವಳಿ ನಕಲು ಸ್ಕೆಚ್ ಕಾಪಿ ಮತ್ತು OM ಕಾಪಿಗಳನ್ನು ನೀಡಲು ರಹ ಇರುವುದಿಲ್ಲರಿಂದ ಹಿಂಬರಹ ನೀಡಿರುತ್ತಾರೆ. ಖಾತೆಯನ್ನು ರದ್ದುಪಡಿಸಲು ಖಾತೆ ರದ್ದುಪಡಿಸಲು ಹೆಂಗಾಗುತ್ತೆ? ಎಲ್ಲ ಕಾಂಟ್ರಾಡಿಕ್ಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್, ಒಂದಕ್ಕೊಂದು ಕಾಂಟ್ರಾಡಿಕ್ಟರಿ. If an endorsement was issued, as we were rightly saying, this should have been the procedure. In last two lines ಅಲ್ಲಿ ರಹ ಇರುವುದಿಲ್ಲವೆಂದು ಹಿಂಬರಹ ನೀಡಿರುತ್ತಾರೆ. That is the correct procedure. ಆಮೇಲೆ where was the need for initiating this proceedings? If their name was entered illegally, then this is not the proceeding. ಖಾತಾ ಸಾಗುವಳಿಯನ್ನು ರದ್ದುಪಡಿಸಿದೆ. Yes. Yes. ಆಯ್ತು. ಇಂಟರ್ನಲ್ ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ. Yes.
2 acres of land in survey number 87/50, made in the name of Mr. Swami Gowda, and Karthikeyan 4 acres of land in survey number made in the name of Devare Gowda. It appears from RTC for the year 2019 and 20 that Jayamma it is going from 2 acres, survey number 187 of bar 16, and Tata changed the name as per bar number so and so dated 27/8/2012 on OP basis. The said RTC further shows that he is in possession of 4 acres of land, survey number, and Tata changed the name as per bar number dated so and so on OP basis. It appears that said RTC loan of 60 lakhs borrowed from the calculated bank 10% and mentioned bar number so and so. And the calculated 10% relation copies of MRS number so and so are ready. Copies of draft certificate dated so and so will be there. To the start of fixation of land.
ಏನ್ರಿ ಇದೆಲ್ಲ ವಾಟ್ ಇಸ್ ಆಲ್ ದಿಸ್ there was no necessity. Now the name of this person has been deleted from the RTC, so therefore they went before the deputy commissioner. What is the finding of the deputy commissioner?
Original cargo certificate, original grant certificate, and original cargo certificate to show that the above 4 acres of land and 2 acres of land is survey number 187/15, or any portion of land is survey number granted to
So the assistant commissioner will have to answer. The assistant commissioner will have to answer. How did he pass that order? Deleting the name. ಎಲ್ಲ ಇದೇ ತರ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನೋಡ್ರಿ. ಯಾವ 20-30 ವರ್ಷದಿಂದ ಯಾವ್ದೋ ಮಾಡಿರ್ತಾರೆ. ಈಗ ಏನೋ ಒಂದು ಕಾರಣ ಹೇಳಿ ಇಲ್ಲ ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅನ್ಬಿಟ್ಟು ದೇ ವಾಂಟ್ ಟು ರಿಮೂವ್ ದಿ ನೇಮ್, ಬಟ್ ದೇ ಡು ನಾಟ್ ವಾಂಟ್ ಟು ಟೇಕ್ ಅಪ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ in accordance with law. On the one hand, they say there is no grant. Therefore, they are required to answer how their names were entered from the past 25 years. Whoever was the original grantee, how his name was entered if there was no grant? How did they continue the name and do mutation by way of inheritance? Everything is lopsided. Okay. Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with the annexures on the learned AGA. Full stop. Next para. It is the grievance of the petitioner that on the guise of cancelling the grant that was made in the year your favor made in the year 1992 date ilva 92-93 in favor of the father-in-law of the petitioner, proceedings were initiated by the assistant commissioner, Ramnagar subdivision in LND bar CR bar 548 bar 2019-20, invoking the powers conferred in rule 108K of the Karnataka land revenue rules. Stop. However, in the orders passed by the assistant commissioner at annexure L, it is contended that no grant was made in favor of the petitioner's father-in-law. Full stop. Therefore, the question is, if there was no grant made in favor of the petitioner's father-in-law, then there could not have been initiation of proceedings for cancellation of the grant. Full stop. However, on that ground, the name of the petitioner is ought to be removed from the record of rights by the order passed by the Assistant Commissioner. Stop. When the petitioner approached the Deputy Commissioner, the Deputy Commissioner dismissed the appeal without objectively considering the contentions of the petitioner. Stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned orders at annexures L and M till the next date of hearing. If the revenue entries have been mutated and removed, the respondent authorities are directed to restore the same forthwith. Rೇ ಏನ್ ಮಾಡಿದ್ರು ಕರೆಕ್ಟ್ ಆಗಿ ದಿಸ್ ಇಸ್ ದಿ ಅಲಿಗೇಷನ್ ಅಗೇನ್ಸ್ಟ್ ಯು, ಯು ಪ್ಲೀಸ್ ಆನ್ಸರ್ ಟು ದಿಸ್ ಅಂತ ಹೇಳಿ ಅವ್ರನ್ನ ದೇ ಶುಡ್ ಕಾಲ್ ಅಪ್ ಆನ್ ದೆಮ್. ಏನು ಇಲ್ಲ. ಎಸ್. ಸೊ ದೇರ್ ಫಾರ್ ಇಬ್ಬರನ್ನು ಕರೆಸಿ ಈ ತರ ಆಗಿದೆ, ವಾಟ್ ವಾಸ್ ಗ್ರಾಂಟೆಡ್ ಒನ್ ವಾಸ್ ಓನ್ಲಿ. Sir, there is no provision for invoking the powers conferred under rule 108K. It is the case of the authorities that what was granted to that person was so much, what was granted to the other person was so much, but excess has been shown in the revenue entries. Alva? Where is the question of invoking rule 108K for that? Proceeding should have been initiated under 136(2). Yes.
And then, Chandrasekhar B. Chandrasekhar B.
On 9/6/2023, although none appeared for the petitioner, this court had granted 2 weeks time finally for complaints of office objections. Full stop. Office objections have not been complied. Full stop. Today too, there is no representation for the petitioner. Full stop. Next para. However, as a last opportunity, a week's time is granted to the petitioner for complaints of office objection. Full stop. Release this matter on 18th of January 2024. Full stop. If office objections are not complied by the next date of hearing, the writ petition will be dismissed. Yes. Second para of verifying affidavit to be stated correctly. Typed copy of annexure D to be furnished. Village map the type copy ಕೊಡ್ರಿ ಅಂದ್ರೆ ಏನ್ರಿ ಏನ್ ನೋಡೋದಿಲ್ಲ ಏನು ಇಲ್ಲ. Office objection is overruled. You don't have the file. At the request of learned counsel for petitioner, release this matter for preliminary hearing on 18th of January. Finally, 2 weeks are granted for compliance of office objections. Full stop. Release this matter on 24th of January 2024. Full stop. If office objections are not complied by the next date of hearing, the writ petition will be dismissed. Yes. Huh? Office objection ಬಗ್ಗೆ ಹೇಳ್ರಿ. ಹಾ ಹಾ Annexure D and E. In respect of the office objections, learned counsel for the petitioner submits that proceedings were initiated at the behest of the respondent, range forest officer, Makutta range, Vijayapura, Virajpet division, against many such persons. And since the petitioner is aggrieved of the impugned order, he is before this court. Full stop. The other parties are owners of several other portions of land, and they are not connected in any manner to the writ petition. Full stop. Therefore, they are not made parties to the proceedings. Full stop. Next para. The submission of the learned counsel for petitioner is accepted. Office objection is overruled. ಅದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆಯಾ? ಕೊಡಿ ಹಂಗಾದ್ರೆ. ವಾಟ್ ಇಸ್ ದಟ್ ಆರ್ಡರ್? ಓನ್ಲಿ ನೋಟಿಸಾ? ಓನ್ಲಿ ನೋಟಿಸ್. Learned AGA, HCGP takes notice for all the respondents. Learned counsel for petitioner is direct serve a copy of the petition along with annexures on the learned HCGP. Full stop. List this matter along with a first matter really. WP number 6339 of 2020. Yes. Annexure J. J no. Huh?
ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಡಿವೈಡೆಡ್ ಒಬ್ಬರಿಗೆ 25 ಗುಂಟೆ ಬರುತ್ತೆ, ಇನ್ನಿಬ್ಬರಿಗೆ 50 ಗುಂಟೆ ಬರುತ್ತೆ. ನಾನು ಕೂಡ ಹಾಕಿದಾಗ ಈ ದರ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಮೋಹನ್ ಕುಮಾರ್ ನಾಗರಾಜ್ 99 they have filed objection for conducting court. Therefore, I find that there is something before Samtika side DDL. ಇದೇನಾಗ್ತದೆ ಪಾರ್ಟಿಗಳು ಯಾರು ಎಲ್ಲಾರು ಪಾರ್ಟಿ ಮಾಡ್ತಾರೆ ಆಟೋಮೆಟಿಕ್. So I'm not made in party. So technical ಆಗಿ ಮಾಡೋದು. ಕಳಿಸಿದಿ RC ಅನ್ನಿಸಿದ್ರೆ ಈ ಪ್ರಾಬ್ಲಮ್. ನನಗೆ ಅಪೋಸ್ ಮಾಡಿರೋದು ಬಿಟ್ಟು RC ಯಾರು ಇರ್ತಾರೆ ಎಲ್ಲರೂ ಆಟೋಮೆಟಿಕ್ ರೆಸ್ಪಾನ್ಸ್ ಮಾಡ್ತಾರೆ. I am not made in parties before the DDL. ಈ ಅಬ್ಜೆಕ್ಷನ್ ಆಗೋದ್ರೆ ನಾನು ಲೀಡರ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್ ಇರಬೇಕು ನಾ ಪೊಸಿಷನ್ 25 ಗಂಟೆ ಪಕ್ಕದಲ್ಲಿ ಇನ್ಸ್ಟೆನ್ಸ್ ಆಗಿರುತ್ತೆ. How can dispute ಮಾಡಿ
ಯಾವ ಇದು annexure J is a sketch. Where is that reference? Mariappa and Venkata Muniyappa. Annexure J is a sketch. Huh? ಅದು annexure K ಅದು.
technical and extra issue intent of land.
Venkatachalappa, Mariyappa, Venkata Muniyappa.
ನಾನು ಐ ನಾಟ್ ಪ್ರೆಸೆಂಟ್ ಪಾರ್ಟಿ ನಾನು ಕೋಡ್ ಮಾಡೋ ಅಪ್ಲಿಕೇಶನ್ ಅಂತಿದ್ದೆ ಇವು ಅವ್ರು ಪಾಣಿ ತಗೊಂಡು ಪಾಣಿ ನಮ್ಗೆ ಯಾರು ಎಲ್ಲರೂ ಕರ್ಕೊಂಡು ಐ ನೋ ಗಿವನ್ ಸೆಕೆಂಡ್ 5 and 6 ಅವ್ರು 25 ಮುಂಚೆ ಪಕ್ಕದಲ್ಲಿದ್ದಾರೆ ಐ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್ even they are not disputing my guideline position ನಾನು ಐ disputing only 1 2 3 4.
Sir, in your petition before the technical assistant, where you are the petitioner or your father was the petitioner, it is your petition. You are claiming under Venkatachalappa, isn't it? Venkatachalappa is the appellant there.
ನಾನು ಅಪ್ಲೈ ಮಾಡ್ತೀನಿ ನನ್ನ ಬ್ಯಾಂಕ್ಗೆ ನನ್ನ ಅಪ್ರೂವ್ ಬಂದಿದೆ 64 ಬರೆಯಬೇಕು some third party 9% objection ಮಾಡಿದ್ರು ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಿದ್ದು 1 2 3 4 ನಾನು ಏನ್ ಮಾಡಬೇಕು ನಾನು ಯಾರು ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡೋದು ಅವರಿಂದ ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಿ ಪ್ರೊಸೀಡಿಂಗ್ ಶುರು ಮಾಡಬೇಕಾದ್ರೆ ನಾನು ಶುರು ಮಾಡೋ ದೇ ಇನ್ಕ್ಲೂಡ್ ಆಲ್ ದ ಪರ್ಸನ್ಸ್ ಹೂ ನೇಮ್ಸ್ ಆರ್ ರಿಲೇಟೆಡ್ ಆಗಿ ಈ 5 and 6 ನಾನು ಪಾರ್ಟಿ ಮಾಡಿದ್ದೇ ಇಲ್ಲ ದೇರ್ ಇಸ್ ನೋ ಸಚ್ ಕಂಡೀಷನ್
ಬರ್ಕೊಳ್ಳಿ.
ಅವರು ನಾನು
In respect of the office objection that Sri Mariyappa and Sri Venkata Muniyappa, who are party respondents number 5 and 6 at annexure K. ರೀ ಇಲ್ಲಿ ಬರ್ದಿರೋದು ನೋಡ್ರಿ, ಕೊಡ್ರಿ ಅವ್ರಿಗೆ. ಇನ್ನೊಂದ್ಸರಿ ಒಂದೊಂಥರ ಹೇಳ್ತಾರೆ ಇಲ್ಲಿ. ನೀವು ಅಲ್ಲಿ ಮಾತ್ರ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಇಲ್ಲಿ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ಏನಿದೆ ಕರೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲಿ ಕರೆಕ್ಟ್ ಮಾಡೋದು ಬೇಡ ಹಂಗಾದ್ರೆ ಮತ್ತೆ
who are the parties respondent 5 and 6 at
annexure K are not made parties to these proceedings. Learned counsel for the petitioner submits that a note has been put up below the past title saying that Sri Mariyappa and Sri Muni Venkata Muniyappa are not necessary parties to these proceedings and no claim is made as against those persons and therefore they are not made parties to these proceedings. Full stop. The submission of the learned counsel for petitioners is accepted. Full stop. Office objection is over. Yes. ಹೇಳಿ ಸರಿ ಆಯ್ತು. You want to make submissions for preliminary hearing, you make. Why should we list it again? There is no interim prayer. ಅಲ್ರಿ ಏನ್ interim prayer ಇದೆಯಾ? Why don't you make submissions? ಮತ್ತೆ only issuance of notice Learned HCGP takes notice for response number 1 to 3. Issue notice to response number 4 to 9. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned HCGP. ಕೋರ್ಟ್ ಫೀ ಯಾವಾಗ? Deficit court fee of ₹400 to be paid. So please comply. At the request of learned counsel for petitioner, a week's time is granted for compliance of office objections. Although 2 weeks were finally granted by order dated 12/6/2023 for complaints of office objections. Office objections have not been complied. Full stop. There is no representation for the petitioner. Full stop. However, in the interest of justice, finally, the reach time is granted for complaints of office objections. Full stop. Release this matter on 18th of January 2024. Full stop. If office objections are not complied by the next date of hearing, the writ petition will be dismissed.
Bill number 21.
Matter is called out. There is no representation for the petitioner. The learned counsel for petitioner is required to answer the office objection as to why respondent number 1 in the proceedings at Annexure C is not made party to this proceedings. Full stop. Release this matter on 18th of January.
22, CH-8.
Court is Katilla. Finally, a week's time is granted at the request of learned counsel for petitioner for complaints of office objection. You don't have a copy of the form number 53, but you have filed acknowledgement.
Based on common.
Where is that? As regards office objection, that a copy of form number 53 is not filed by the petitioner, learned counsel submits that the petitioner does not have a copy of form number 53 or the acknowledgement. Stop. However, the claim of the petitioner can be justified in terms of Annexure D, which is a list prepared by the competent authorities. Full stop. Next para. The submission of the learned counsel for petitioner is accepted. Office objection is overruled. Release matter for preliminary hearing on 19th of January. Huh?
What's in a year? Friend, having obtained
Allah.
interim order, he is keeping quiet.
Allah, you have not served a copy on.
But I had instructed.
I work.
ಅಲ್ಲ ಕಾಪಿ ಇದ್ರೆ ಕೊಡಿ ದಯವಿಟ್ಟು.
Two days, 3 days ಎಲ್ಲ
Rectify. ಅಲ್ಲಲ್ಲ, the office objection there is that they have not served a copy on you ಅಷ್ಟೇ ತಾನೆ. ಏನ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್? Office objection is that you have not served a copy, ಅಷ್ಟೇ ತಾನೆ. Copy not served on the other respondents. Delay days not mentioned.
Notification ಯಾರು ಹಾಕಿದ್ದಾರೆ ಅವರು ಬರ್ತಾರೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿಲ್ಲ ಅವರು
T.N. Venkatesh. Anyway, these applications are filed to bring the legal representative of disease respond number 7 on record. Huh? Who is appearing for respond number 7? Huh? H.S. Chandrasekhar. You are Mrs. Chandrasekhar. Mention ಮಾಡ್ರಿ ಅದೇನು number of days delays you have to mention. Finally, at the request of learned counsel for petitioner, a week's time is granted for complaints of office objections raised on IS number 123 of 2022. Namely, to serve, namely to mention the number of days delay in the application for condonation of delay and to serve copies of the application on the learned counsel for the respondents. Huh? Release this matter on 22nd. That is only to hear the application, it has to formally be allowed. The application has to be formally allowed. Alva? To bring the LRs on record, ಅಷ್ಟೇ ತಾನೆ. ಅದೇ. If you have instructions, you say we can allow the application now itself. He is only trying to bring the legal representative of a disease respondent on record. If you have instructions, you can say yes, it can be allowed. I released this matter on 22nd of January. ಬರ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ it will be considered and it will be rejected. ಅಷ್ಟೇ ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. We can't force them to come. Yes. ಅದ್ಯಾರು ನಿಮ್ಗೆ ಪರಿಚಯ ಯಾರು ಇದ್ರೆ please inform him. The impleading applicant. We do not know whether this respond number impleading applicant. We do not know whether he is trying to support you or support the respondents. Yaru. So therefore, if that is the case, you please ask the learned counsel to come and enter appearance at the next date of hearing. We can consider the application also. Yes. Where you have? Learned counsel for the petitioner submits that along with the memo dated 9/3/2023, the original of the communication and the acknowledgement for having sent the copy of the writ petition along with annexures to the learned counsel for the caveat respondent, Sri B.C. Venkatesh, has been filed. Stop. the contention of the learned counsel for petitioner that copy of the writ petition has been served on the learned counsel for the caveat respondent. Number 1 is accepted. Stop. Yes. You want to make submission? ಹೇಳಿ ಇವಾಗಲೇ ಹೇಳಿ, there is no difficulty. ಏನ್ರಿ ಅದು? ವಾಟ್ ಇಸ್ ದಿಸ್? ಅದಕ್ಕೆ ಇನ್ನೊಂದ್ಸರಿ ತರ್ಸ್ಕೊಬೇಕು. When we are ready, you are not ready. What is this? Release this matter for preliminary hearing on 19th of January. Huh?
Section B.
Annexure B. If you are challenging this order, then the certified copy will have to be produced. Huh? No, you are not challenging annexure B. Hey, ideal, you are also challenging annexure B. Then where is the certified copy? Prayer B. Prayer B, sir. Mata? Certified copy has to be produced. The petitioner is required to furnish the certified copy of annexure B, since the same is under challenge in this writ petition. Stop. At the request of learned counsel for petitioner, 2 weeks time is granted to furnish the certified copy. Saka? Huh? Yes. Yes.
I was getting application. For example, last week, I think my second was not doing.
IA number 2 of 223 for impleading.
This is the classic case of fraud that has been paid again. On 2/6/1918, application to office.
The Durga Parmeshwari Groups, a partnership firm, order on IA number 2 of 2023. It is an application filed for impleading. Stop. Learned senior counsel Shri Dhyan Chinnappa, appearing on behalf of the petitioner, would submit that the petitioner will have no objection to allow the application and permit the proposed impleading applicant to come on record as a party respondent to these proceedings. Full stop. Next para. Accordingly, the application is allowed. The impleading applicant is permitted to be brought on record as party respond number 14 to these proceedings. Full stop. The learned counsel for petitioner shall carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today.
On vacancy this law. So the reason is, finance that is most curious. I purchased property in 82. How about the original owners of the property? There was a tenancy claim which was rejected in 1980. After that, in 82, the property is sold. Now, in 2022, the application is filed by the DPS of that tenant, and a new file comes into existence with respect to a new LRF order. And on that basis, the notice is not issued to me, it is issued to the wrong address. Then paper publication is carried out immediately in some newspaper. And then immediately thereafter, the assistant commissioner passes an order, change the mutation entries. Setting aside the mutation into 83-84 and 93-94 and putting the name of theirs, and within a few months they sell that property to this person. And interestingly, the money is paid to a person who is not a vendor. 2 crores 25 lakhs, at least on the sale deed is there to you. 2 crores 25 lakhs is paid to some consenting witness. And another 2 crores is supposed to have been paid to these owners. The entire thing has been managed in this particular way. And what I without notice to me now, an order has been passed changing all the mutation entries. Now that is some new rights have been created.
We have stated.
Mutation entry has been stayed.
Ah.
But I want to make an application for restraining them from alienating this property.
Yes. Last time itself we had made this. Please file it in the office. Yes. So that copy can be served on the other side.
Data, 2
Yeah, acknowledgement. Is acknowledgement, huh? Huh?
And start sheet is has been served on 28.
Regarding office objection. Come learned counsel for the petitioner submits that the original acknowledgement for having sent the registered post along with copy of the writ petition has been filed along with the writ petition itself. Stop. Therefore, comma, it is acceptable that the copy of the writ petition has been served on the learned counsel for the respondent caveator number 6. Stop. Yes. Yes.
Currently, the order of the deputy commissioner as per annexure S. My name round the second round of litigation before some in all the previous litigation before the concerned authority, the authorities have expressly held a spot inspection is required before making into entry in the petition register. Even this court also got held in annexure R, page number 128. That is the order passed by this court, the previous round of litigation. In that, Lordship may kindly appreciate page number 132. Paragraph C. The petitioners claim to be members of the scheduled caste to whom the allotment of land was made. They claim to be in possession of the land, having constructed residential building under that.
ಯಾವ paragraph ಓದ್ತಾ ಇದ್ದೀರಾ?
Page number 132.
ಹಾ.
Paragraph C.
ಹಾ.
The petitioners claim to be
Yes.
members of the scheduled caste to whom the allotment of land was made. They claim to be in possession of the land, having constructed residential building under the borewell therein for providing irrigation facility for growing the crops and other plantation. At least this ought to have been got spot inspected before making the order of the claim as rightly argued by the counsel for the petitioner. This having not been done, yet another landmark lurks in the impugned order. It is reviewed, taken by this court. Therefore, also not as per annexure yes. Without
In view of the above, the writ petition succeeds.
yes,
Writ of such issues washing the impugned orders. Matters remitted to the
back to the
Deputy
Deputy
Commissioner.
Respondent Deputy Commissioner for consideration afresh.
Yes.
In accordance with law.
yes.
Not this term report. And the other authorities concerned have repeatedly and consistently held a spot inspection is very much required to make the entry in the petition register. In the Lord, the Deputy Commissioner ignoring all this Lord as set aside the order of the Assistant Commissioner, in which the invitation register was set aside.
Grant made in favor of Sri Venkatramaya and Dodnarasaya is said to have been cancelled.
This allegation.
Huh?
But the Lordship may kindly appreciate the documents at annexure D. That is the order in which under which the grant set to have been cancelled. Lordship may kindly appreciate the next document. Index of lands. Page number 84.
Index of land ಹೆಂಗ್ರಿ ಹೋಗ್ತೀರಾ?
ಕ್ಯಾನ್ಸಲ್ ಆಗಿದ್ರೆ ಕ್ಯಾನ್ಸಲ್ ಆಗಿರೋದು ದೊಡ್ಡ ನರಸಯ್ಯನಿಗೆ. Wrongly it is interpreted as cancelled in favor of Venkatramaya also. That is forthcoming in all the documents. Even the authorities below also held that the land granted in favor of Venkatramaya has not been cancelled. That is the consistent observation.
Where is that order of cancellation?
Not annexure D.
Page number?
Page number 82. This was the subject matter.
Yes.
Venkatramaya 6 acres, Doddanarasaya 4 acres. Last from below paragraph,
Yes.
from last two lines. The revenue inspector Eburu Obli reported Sri Venkatramaya do not at all cultivated this surplus land. His whereabout is not known. That is the only observation. Then he also reports that Doddanarasaya, another grantee, has sold along his land to Sri Chennai Goda, and this Chennai Goda has in turn sold
away the same land to Sri Gangaya, in whose favor Pakka Podi work has been done. Besides this, the said Gangaya has mortgaged these 4 acres of land to TCLD Bank, Tumakuru. The revenue inspector has enclosed the mutation register extract, wherein details of transaction are noted or made perusal. As verified from the Sagod deed issued to the Dodda that there is a binding that he should not have alienated Darka's land for a period of 10 years. In above circumstances, he has violated the binding of the root of Sagod issued wherein, hence the sale transaction and also other transaction with the PCLD bank are illegal. I request you to kindly take suitable action in the matter. Entire record company. Not the violation.
It is only a communication. It's not an order.
Yes.
It's a communication.
Then.
Ah.
The next document, actually, page number 84. Another one, that act, only the land granted in favor of Dodda Narsaya Act cancelled. The entry is there. Then, Yama, annexure. Yeah. Page number 87. Yama 42, 76, 77. In this also, it is mentioned as land granted to Dodda Narsaya has been cancelled. Then, the Lordship may greatly appreciate. Annexure J, page number 100. The Assistant Commissioner hold a spot inspection. He also appreciate that this Venkramaya was in possession of the property and land granted to him has not been cancelled. That is on 25/11/1998. Then, Lord, the respondent number 6, caveat. Then your Lordship may greatly appreciate annexure L 105. It is the order passed by the Deputy Director of.
When was this land allotted to the other person?
Not respondent number 6.
When?
He has been granted land in the year 95-96 as per the order of the Akrama Committee, fourth respondent. But the grant is overlapping the grant made in favor of the petitioner.
Yes.
Such background grant, the spot sale inspection is very much required.
No, sir. That is not the relevant factor for consideration. The relevant fact for consideration is that they will have to furnish the order by which the grant was cancelled.
They have paid me not.
Unless the grant order was cancelled, there was no occasion for granting the same land to another person. It is as simple as that. Learned HCGP takes notice for response number 1 to 5. Issue notice to respond number 6. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned HCGP. Stop. Next para. Learned counsel for the petitioner submits that although there was a specific direction issued by this court. Clear page number?
Page number 5. 132. Next R.
In WP number 33644 of 2018, dated 17th of November 2022, in the writ petition filed by respondent number 6 that the respondent authorities were required to make a spot inspection before passing orders of the kind take away the legitimate rights of the petitioner herein, comma, the respondent deputy commissioner has once again passed the impugned order at annexure S without conducting any spot inspection. ಮಾಡಿದಾರೇನ್ರಿ? Stop. Moreover, comma, it is submitted that there is no material placed on record at the hands of the sixth respondent or the Tahsildar, comma, Tumkur Taluk to show that the original grant made in favor of the petitioner's father, Sri Venkataramaya, was at any point of time cancelled. Full stop. The order of cancellation in respect of another person, namely Dodda Narasaya, is sought to be made use of to say that the grant made in favor of Sri Venkataramaya also was cancelled. Full stop. The learned counsel would therefore submit that unless there is material to show that the grant made in favor of Sri Venkataramaya was cancelled, comma, there was no occasion for the grant of the same land in favor of the sixth respondent. Full stop. Next paragraph. The learned counsel for petitioner has made out a prima facie case. Full stop. Consequently, there shall be an ad interim order of stay of the impugned order at annexure S till the next date of hearing. Full stop.
Yeah, data three. Leading.
Not 79 AB, yeah? Huh? Non-amendment of prayer in this petition. By which order you are directed to amend the finally, a week's time is granted at the request of, even for amendment of the prayer, you can do it now itself. Please do it, sir. A week's time is granted for amending the prayer in terms of earlier writ petition. Allah, sir, by order dated 21/3/2023, your submission was accepted. Taking note of the above submission, as the amendment as read in the application would not change the nature of the writ petition, and it would not prejudice the case of the respondent, it is deemed appropriate to allow the amendment application. Accordingly, IA number 1 of 2022 is allowed, and the petitioner is permitted to carry out the amendment by adding additional grounds and additional prayer. Idin complaints madilla neevu. Please do it.
Finally, a week's time is granted for amending the prayer.
For amendment of the grounds and prayer in terms of the order dated 21/3/2023. Yes. Already ನಿಮ್ಮ ಹತ್ರ ಆಗ್ಲೇ ಇದೆ document. In your application it is there. Kindly type it and put it ಅಷ್ಟೇ. You need 2 weeks for that one? Adalla, we are not concerned with any other thing. In your application, whatever your amendment you had sought, you have to incorporate in the petition. ಅದಕ್ಕೆ ಬೇರೆ documents ಏನ್ ಬೇಕು? No. Yes.
Number 30, Narayan Swami TM.
Yes. You purchased in the year 2006. Please come to the synopsis. When was the order passed by the Assistant Commissioner? Well, late 2015. ಆಮೇಲೆ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. You did not challenge the order. ಆಯ್ತು, ಅದೇ ಸೇಮ್ ಆರ್ಡರ್ as in WP number 3271 of 2022, dated 17th of February 2022. ಆ relevant changes ಮಾತ್ರ ಮಾಡ್ಬೇಕಷ್ಟೇ ಅದರಲ್ಲಿ. ಆರ್ಡರ್ ಆಫ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮತ್ತೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಂಬರ್ ಇದ್ರೆ ಆ ನಂಬರ್. ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಫಾರ್ ಅಪಿಯರೆನ್ಸ್ ಬಿಫೋರ್ ದಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆನ್ 6th of February 2024. Please come to the synopsis. Yes. When did you purchase the land? Yes. When was the order passed? 2009. Then you approached the tribunal. Rejected the appeal.
Only so delay.
Then you did not file the writ petition immediately thereafter. Again, here is a delay. ಇನ್ನೊಂದು ಆರ್ಡರ್ KT ಮುಂದೆ ಹೋಗಿದ್ದಿತ್ತು, ಅದ್ಯಾವ್ದಿದೆ? ಇದರಲ್ಲಿ KT ಇದರಲ್ಲಿ ಬೇರೆ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ರು ನೋಡಿ, ಅದು ಯಾವ್ದೊಂದು ತೆಗೆದಿಟ್ಕೊಳ್ಳಿ. ಇದರಲ್ಲಿ ದಿ ಮ್ಯಾಟರ್ ವಾಸ್ ಪೆಂಡಿಂಗ್ ಬಿಫೋರ್ ದಿ ಟ್ರೈಬ್ಯುನಲ್ at that point of time. ಬೇರೆ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದೀನಿ, ವೇರ್ ದಿ ಟ್ರೈಬ್ಯುನಲ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ದಿ ಮ್ಯಾಟರ್, ಅದು ಒಂದು ತೆಗೆದಿಟ್ಕೊಂಡಿದ್ದು. ಇದು WP number 1217 of 2020, dated 24th of January 2022. Paragraph number 1 and 2. Similarly, paragraph number 3, Berkeley. Admittedly, as on the date of the ordinance, no appeal or any proceedings were pending either before the tribunal or before this court. Stop. Nevertheless, learned counsel for the petitioner submits that in many of such writ petitions, this court took note of the provision contained in subsection 2 of section 12 of the amending act and held that the assistant commissioner has granted the land to third parties after the order of confiscation was passed, then subsection 1 of section 12 of the amending act will apply to say that the proceedings have reached finality. Stop. On the other hand, if the land has remained without being granting to any other party, then subsection 2 of section 12 of the amending act will apply, and all further proceedings shall be declared as abated by the assistant commissioner. Full stop. Learned counsel prays for similar orders. Full stop. Next paragraph. Consequently, this court proceeds to pass the following order. ಅಂತ ಮಾಡಿಕೊಂಡು order portion same. To appear on 6th of February 2024. Yes, synopsis. ಆಮೇಲೆ it was not challenged. It was not challenged. Same as 3271 of 2022. Date for appearance 6th of February.
Number 33, Amartya.
Challenge ಮಾಡಿಲ್ಲ. So same order. 6th of February. Yes.
Number 34, Sukkareddy.
Hmm. 2009. Same order. ಅವ್ರೇನೋ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಅಷ್ಟೇ, ಏನ್ ಮಾಡಕ್ ಎಸ್ ಸೇಮ್ ಮಾಡಕ್ 35 also same. Yes. All right.
Number 36, we are Subramania.
Early hearing. State ಏನಾ ಅದರ್ ಸೈಡ್ ಯಾವ್ದೋ ಟೆಂಪಲ್ ಇದೆ ನೋಟಿಫೈಡ್ ಟೆಂಪಲ್.
These were sitting in the temple.
ಹಾ
And they made an application under Karnataka land.
ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್ ಆಕ್ಟ್. ಹಾ ಹಾ
Therefore, we have filed, this honorable court remanded the matter because it is not the application before the land tribunal, and this act, it must go before the deputy commissioner.
Hmm.
If the matter was sent to the deputy commissioner, the deputy commissioner, without issuing notice to the petitioner also, strictly dismissed my application on the grounds that I have not furnished. Prior to 1/3/1974, I was in occupation. Therefore, I have filed appeal before the Karnataka appellate tribunal.
ಹಾ
The appellate tribunal dismissed my appeal on the technical ground that they should not have filed application before the land tribunal, and they ought to have been filed before the court. So there is straight away it has been rejected. That's why I before your lordship.
ಏನ್ ಮಾಡೋದು? ಸಿ ಯು ಅಡ್ಮಿಟ್ ದಟ್ ಸಚ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ವಾಸ್ ನಾಟ್ ಫೈಲ್ಡ್ ಬಿಫೋರ್ ದಿ ಕಾಂಪಿಟೆಂಟ್ ಅಥಾರಿಟಿ. ದೆನ್ ವಾಟ್ ಟು ಡೂ ದೆನ್? ಅಲ್ಲ, ಬೋನಫೈಡ್ ಮಿಸ್ಟೇಕ್ ಅಂತಂದ್ರೆ ಈ ಕ್ವೆಶ್ಚನ್ ಈಸ್ ವೆದರ್ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಕರೆಕ್ಟೆಡ್. ಹೌ ಕ್ಯಾನ್ ಇಟ್ ಬಿ ಕರೆಕ್ಟೆಡ್? ಹಾ
Thus, that mistake has been rectified by the honorable court and it has been sent to the deputy commissioner.
ಹೌ ಕ್ಯಾನ್ ವಿ ರೆಕ್ಟಿಫೈ ಇಟ್ ಸರ್?
That is the order passing, I have published the restriction number also. This is in restriction number, your lordship will get it, page number 3, in the middle, 11,328 of 2000.
ಸರ್, ನಮ್ಗೆ ಎಲ್ಲಿದೆ ಪವರ್ ಆತರ ಮಾಡೋದಕ್ಕೆ? ಹಂಗೆಲ್ಲಿ ನಮ್ಗೆ ಹೌ ಡು ವಿ ಗೆಟ್ ದಿ ಪವರ್ ಟು ಸೇ ನೋ ದಿ ಅಪ್ಲಿಕೇಶನ್ ಇಸ್ ಫೈಲ್ಡ್ ಬಿಫೋರ್ ಸಮ್ ಅದರ್ ಅಥಾರಿಟಿ, ಲೆಟ್ ಇಟ್ ಬಿ ಟೇಕನ್ ಆಸ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ಡ್ ಬಿಫೋರ್ ಯು? ಹೌ ಕ್ಯಾನ್ ವಿ ಸೇ ದಟ್? ಇಟ್ ಇಸ್ ನಾಟ್ ಪಾಸಿಬಲ್.
This is how this litigation continues from 2010.
ಇರ್ಬೋದು ಸರ್. ದೇ ಸೆಂಟ್ ಇಟ್ ಬಿಫೋರ್ ದಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್. Deputy commissioner is again saying the same thing. Even he will not have the powers to say, all right, I will accept that application you filed before the land tribunal. How can he say? The mistake, sorry. The question is whether it can be rectified.
Instead of land tribunal, I
How?
do admit that mistake. Because everything is borne out by the records. This is the proceeding. That is the situation. First, I leave it to you.
No, you will have to, you sir, ನೀವ್ ಹಿಂಗ್ ಹೇಳ್ಬಿಟ್ರೆ ಆಗೋದಿಲ್ಲ. There has to be, ಅದೇ ಏನು ಇಲ್ವಾ? There is nothing. ಇಲ್ಲಿ unlike you filing a suit or a petition before a wrong forum, and this court would direct, in fact, provision is made in law itself for taking the receiving the matter back and filing it before the court having jurisdiction. There is a provision. ಆತರ ಪ್ರಾವಿಷನ್ ಇಲ್ಲೆಲ್ಲಿದೆ? And you have not furnished a copy of that order also, previous order. You are saying, no, it,
I apply for certificate copy and
certified copy vehicle namge. I just want to read what is the permission that was granted. You say the permission was granted. What is the permission that was granted?
back. Then appeal was filed before the.
Hmm.
after the-
Why have you not furnished a copy of that order? Huh?
Last. Records available, I have.
IA number 1 of 2024 stands disposed of while listing this matter for final hearing on 23rd of January 2024. Full stop. In the meanwhile, learned counsel for petitioner is requested to furnish a copy of the orders passed by this court on the previous occasion in writ petition number
11,328 of 2000. 2010.
ಇನ್ನೊಂದ್ಸರಿ ಹೇಳಿ number.
11,328 of 2010.
Yes.
Sorry. Date 23rd January. Either earlier or after. 23rd I have not been looked at this. I will not be able to attend it.
ಹೇಳಿ.
25th.
ಆಯ್ತು 25th. 25th. Yes.
Permission to deposit amount.
My government order dated 31st August 2023.
Disposed of.
Both the matters are disposed of by an order dated 31st August 2023. But the direction. I will read the. The order dated 31st August 2023. And read the relevant portion, the operative part. We have paragraph 4, page number 6 of the order. Then says that in the light of the above, these institutions stand before stop with the specific direction of the special land acquisition of the NHA release sum of 92 lakhs from out of the compensation paid to right correspondence here in favor of KSIIBC and a sum of 50 lakhs so and so in favor of Karnataka State Finance Corporation who are the petitioners.
Right?
The meeting is done through a platform called Movie Rajni. It does not recognize the petitioner as beneficiaries. Only the name of the reflected in the revenue records. They only then we can deposit in their favor. But there is an order. Without the direction of the alternate, we can possibly use the ISO that can be dispersed. It's only decision of the government.
Order on IA number 1 of 2023. This writ petition was disposed of by order dated 31/8/2023, directing the Special Land Acquisition Officer, NHAI, Chitradurga, to release a sum of rupees 92 lakhs from out of the compensation payable the private respondents herein in favor of KSIIDC and a sum of rupees 50 lakhs 3,600 in favor of Karnataka State Financial Corporation, who are the petitioners in these two writ petitions. So, however, this application has been filed at the hands of
That officer.
the Special Land Acquisition Officer, NHA, citing some difficulty in complying with the directions issued by this court. Full stop. Learned counsel appearing on behalf of the applicant submits that there are some technical issues since the entire process is digitized, the SLAO is not in a position to transfer the amount as was directed by this court in favor of the two petitioners herein. Full stop. The learned counsel will therefore submit that the directions may be modified to enable the SLAO to deposit the amounts before this court, and thereafter this court may direct the deposit of the amounts in accordance with the directions issued earlier. Full stop. Next para. The learned counsel for the counsels for the petitioners do not have any objection to the submission made by the learned counsel for the applicant. Full stop. Next para. Consequently, while allowing the application, the operative portion of the orders passed by this court stands modified while directing the Special Land Acquisition Officer, NHAI, Chitradurga, to deposit the said sum of rupees 92 lakhs and 50 lakhs 3,600 before this court within a period of 2 weeks from today, 3 weeks from today. Full stop. Next para. As and when the amounts are deposited by the SLAO, registry is directed to redeposit the amounts as was directed by this court earlier in favor of KSIIDC and KSFC, who are the writ petitioners herein. So, yes.
Yes, actually, the authority has. Left out of 15,78,000 for this summer, provided to that center. So they have, in fact, a court permit, court orders, and the bit amount, then the portion, remaining amount also.
But ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ವಲ್ಲ ಅವರು.
They have.
Why have you not indicated about that in your application? That there is some more amount lying. At this juncture, learned counsel for the petitioner KSFC has brought to the notice of this court a communication dated 10th of October 2023 made by the DGM bracketly technical and project director, NHA, Chitradurga, that a sum of rupees 15 lakhs 78,288 is also lying with the authority in excess of what was earlier submitted before this court. Stop. Who appears for that fourth respondent. He has to give the consent, isn't it? That's what we do not know. Or more than that. No, but then without the consent of that party, we cannot direct. We will direct the listing of the matter. ಅಲ್ಲ ಆಯ್ತು ಇರ್ಬೋದು, but without consent of the both, this order itself has been passed at the consent of the fourth respondent, isn't it?
Is lying with the NHA in excess of what was earlier submitted by before this court.
Stop. The learned council would therefore request that the said amount of rupees 15,78,288 may also be distributed amongst the petitioners. Stop. Next para. However, there is no representation for respondent number 4, who is required to give his consent. Stop. Therefore, release this matter on 19th of January. Please inform that learned council, let him come with instructions. ಕೊಟ್ರಿ ಅದು ವಾಪಸ್. Seven 473 days delay in filing the application. Orders on IA number 1 and 2 of 2023. These applications are filed by the petitioner for recalling the order dated 22/8/2022, whereby the petition was dismissed for non-compliance of office objection. Stop. Learned counsel for the petitioner submits that the petitioner is a senior citizen and ex-serviceman seeking grant of lands the office objection was for furnishing the age proof of the petitioner and type copies of the manuscripts. Full stop. Next para. This court has gone through the said annexures and finds that there is no need for furnishing the typed copies. Full stop. Therefore, while overruling the office objections, the application is allowed. Stop. The order dated 22/8/2022 is recalled. Full stop. The petition is restored to its original file. Full stop. Next para. Release this matter for preliminary hearing on 19th of January.
Serial number 39. I am for the petitioner, my lord.
2023 matter, you were asking for early hearing.
ಅದು matter is fully covered by the judgment of this honorable court.
ಇರ್ಬೋದು sir, but this is not the way.
Because despite the order of stay granted by this honorable court, the vested interest in the locality.
No. See, if you are asking for interim orders, you should have convinced this court at the time of
interim order ಕೊಟ್ಟಿದ್ದಾರೆ, interim order.
Therefore, where is the question of early hearing? The matter is filed in the year 2023 and you want early hearing.
State is the only party. Everything ready for disposal. Matter is fully covered by the judgment.
Let us see.
This IA at least may be called after some days.
Release this matter. Release this matter on 30th of January 2024. Yes.
Much obliged. Much obliged. Much obliged. In the meantime, our record ತರಿಸ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಅವರು.
ಅಲ್ಲ sir, if you are saying that matter is covered, where is the question of
Yes,
securing the original record?
Fully covered, fully covered.
Fully covered by an order ಅಂತಂದ್ರೆ where is the need for securing original records?
Not necessary. Since it's an order, I thought I can bring it to the
Yes.
That's one number 10, my lord, in the other occasion, I said, no, I can take notice, my lord, it's not available. Notice will be issued, that's one number 10, my lord. 4 to 9, I will take, my lord, I will.
You know, who is serving a copy on whom?
Petitioner is serving a copy
Of the
of the application of
IA number 1.
Yes.
Learned Counsel for Petitioner has furnished a copy of IA number 1 of 2023 on Learned Counsel for respond number 3. Non-filing of wakalat for respond number 4.
4 to 9, I will undertake, my lord, not 10.
4.
4 to 9.
Learned Counsel Sri K. Prasad Hegde undertakes to file wakalat for response number 4 to 9.
10.
The petitioner is required to take fresh steps for service of notice on respond number 10. Yes. ಏನಕ್ಕೆ? Who is the respond number 10?
but the contesting respondent is already entered.
Release this matter on 18th of January.
ಬನ್ನಿ. ಬನ್ನಿ. ಯಾವ ಚೇಂಬರ್? ಇಂಟ್ರೆಸ್ಟ್.
Five two 7 3 of 2020. 2 1 24. 2 1. 2 1. 24. Really? Eight and more than eight
ಇನ್ನೂ ಬಂದಿಲ್ಲ ಇದು ಆ ಟೈಪ್ ಆಗಿಲ್ಲ. ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್,
ಎಸ್ ಸರ್, ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ತಿದೆ.
ನಾನು ಕೃಷ್ಣಮೂರ್ತಿ ಹಾಸ್ಯಗಾರ್ ಮಾತಾಡ್ತಾ ಇದ್ದೇನೆ.
ಹೌದು, ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ತಿದೆ.
ಈ 39ನೇ ಮ್ಯಾಟ್ರು, ಹಲೋ,
ಕೇಳಿಸ್ತಿದೆ, ಹೇಳಿ ಸರ್. 39ನೇ ಮ್ಯಾಟ್ರು.
39ನೇ ಮ್ಯಾಟ್ರು, ಈ 39ನೇ ಮ್ಯಾಟ್ರು ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುದಿತ್ತು. ನಾನು 2:15 ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೇನೆ, ಅದು ಮರ್ತೋಗ್ಬಿಟ್ಟಿತ್ತು.
39.
39
ಆಯ್ತು ಸರ್.
ಅದು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗ್ಬೇಕಾಗಿತ್ತು, ನನಗೆ ಮರ್ತೋಗ್ಬಿಡ್ತು ಅದು. ಈಗ 30ನೇ ತಾರೀಕು ಇಟ್ಕೊಂಡಿದ್ದಾರೆ, ಅದು ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೇನೆ 2:15 ದಯವಿಟ್ಟು.
ಸರಿ ಸರ್, ಆಯ್ತು.
ಫೈಲ್ ಒಂದು ದಯವಿಟ್ಟು ಅಲ್ಲೇ ಇಟ್ಕೊಂಡಿರಿ.
ಅಲ್ಲ, ಹೇಳಿದೆ ಬಿಡಿ ಸರ್, ಆಯ್ತು. ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ನಾನು ಫಾಲೋ ಅಪ್ ಮಾಡ್ತೀನಿ.
ಹೌದಾ? ಓಕೆ, ನಾ 2:15 ಸಬ್ಮಿಷನ್ ಮಾಡ್ಲಾ? ಓಕೆ.
ಇನ್ನೊಂದು ಆಗುತ್ತೆ
ಹಲೋ
ಸರ್, ಆಗುತ್ತೆ ಸರ್, ಮಾಡಿದ್ರು ಆಗುತ್ತೆ, ಮಾಡದೇ ಇದ್ರು ಆಗುತ್ತೆ.
ಹಾ. ಆದ್ರೆ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗ್ಬೇಕು. ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೇನೆ 2:15.
Because numbers. ಇಲ್ಲ ಹೋಗಿ ಮಾತಾಡು. Sorry.
With your lordship's kind permission,
Yes,
in serial number 39, I'm sorry, I
Huh.
forgot to make a request for extension of the interim order.
all right.
That may
Yes.
kindly be
All
ordered.
right.
39,
Yes. Yes,
please. Much
Really?
obliged.
Hmm? All right. Yes, ಹೇಳಿ ಇವ್ರ ಜೊತೆಗೇನೆ ನಿಮ್ದು ಏನು ಹಾ ಹೂ ಮೂಡ್ ದಿ ಮ್ಯಾಟರ್ ಹಾ Bill number 43. The request of who is asking for adjournment now? For the learned counsel for petitioner release this matter on 18th of January. Yes. ಅಲ್ಲಿ ಇನ್ನು ಬಹಳ ಜನ ಅಡ್ವೊಕೇಟ್ಸ್ ಇದಾರಲ್ಲ. ಪ್ಲೀಸ್ ವೇಟ್ ಇಲ್ಲ ಬೇರೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಇದಾರೆ ಇನ್ನು. ಎಸ್ ಅದು ಕರೀರಿ ಕಾಂಪ್ರಮೈಸ್. Yes.
Therefore, we have the land of the West. This fact was not come to knowledge of the daughter. She adopted a son, not on 15th of 1948 by adoption deed. He came to know about this. Then not he tried an application with the the deputy commissioner restored the not the restoration. Some people do not file applications, said that he is not is the son, therefore they are telecast.
Therefore?
Restoration of Ada has to be cancelled. Then Lord, what happened, Lord? Then he filed an application with the deputy commissioner, attending that he drop itself. Then the deputy commissioner after has said that since he has not produced proper documents to establish because he is not a threat to the people, then he is not able to present material to show that he is not. He was rejected. Then Lord, he filed a repetition before the Court of Karnataka. This is before the sound report. As per answer, he Lord, by order date 16 August 2016, the court came to the conclusion that the matter is adjudicated with adoption and the adoptions and all. Therefore, Lord, Lord, can you see that page 56? Council obtained from the petitioner service, the petition will be discussed at this ground with liberty to the petitioner to approach the civil court to work out his rights within the service. Therefore, not a suit was filed. Suit was filed for injunction and not the declaration. Declaration that is adopted. Not the municipal court.
It was filed against whom?
State government.
State government.
Yes.
Ah.
And as well as, not in detail, I'm sorry, in detail what happened, in the land between Pada, some persons did not file applications before the technical, consent authority. To allow certain portion of the lands in this. All the certificates are given. Then we got this, not, he contested the proceedings contended that he is not an. The civil court not gave a finding, the municipal court, gave a finding that injunction was granted and saying that he the petition before the law is the in possession. But the declaration of adoption therefore we find the state court, the state court not fully allowed to against which I learned not by the second appeal, that is before the logic, that is, RSA 110. Now that matter is settled. Now with this repetition, not the. Now the. He got on the ground, what we can see. Seven. That is restoration. It is order of restoration. Thereafter, what? Restoration of data. Then you know, annexure B is the key code. It's certified. ತಕ್ಷಣ ರದ್ದುಗೊಳಿಸಿ. It's 34. It's D. Already 35 last. ಹೆಸರಿಗೆ ಎಕ್ಸ್ಪ್ಲೋರ್ ಮಾಡಿರುವ ಆದೇಶವನ್ನು ತಕ್ಷಣದಿಂದ ರದ್ದುಗೊಳಿಸಿ. Against which appeal was filed. And there was a lot of 48.
Yes. Yes, I have read that.
Then Mundia did not back the sound like that. He has not told them. I challenge this order before this order. This order was permitted me to withdraw the petition and change the news. Now we not the civil court has given the finding that is not that have the doctors are not system. Or once it has been done, now that order has to be formally accepted and not this. Then we not the compromise petition. Then the second appeal has to be compromise petition.
Where the filed compromise petition in RSA.
Just because RSA has filed, I can't say this relief in that RSA. Formally it happens.
these appellants,
Yes.
the original appellant, Shivannachari, huh?
He died.
He was a defendant only because he contested
Yes.
the issue,
Yes,
huh?
yes, he had no personal interest.
Then why is it that portion of the property is now given to them?
Because they are in possession of the constructed the house.
Huh?
What happened is.
Huh?
So when it's take up 128 Kunda, they see that they are.
He tried to take some right in this property.
Hmm.
Tried to, so he had no right. He had forcefully consulted the house and there is a legal fight. Because appeal was filed. Therefore, not the Shivannachari practically was very old. Not to settle the matter, he was. They ended up releasing some land and that will be settled. That's all the matter has been settled. Before the settlement, not in right. He's now his legal representative.
The plaintiff sought for declaration.
Yes, declaration as well as injunction. The injunction was granted by the trial. And it is negated declaration.
Hmm.
Declare that he was on the documents. So that the appellate court has reversed the finding with regard to that findings of the trial court with regard to the relief of declaration. The suit is defeated.
That's how we do.
Yes. Please call the parties. These are the appellants. Appellants. ಎಲ್ಲars are the appellants. Any ಹೆಸರು? ರಾಜೇಶ್. ಈ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಏನ್ ಬರ್ದಿದ್ದಾರೆ ಗೊತ್ತಾ? ಏನು ಕೊಡೋದು ಅಂತ? ಹಾ, ನಿಮಗೂ ಗೊತ್ತಿದೆಯಾ? ಹಾ, 1 ಎಕರೆ 28 ಗುಂಟೆ ನಿಮ್ಗೆ, ಮಿಕ್ಕಿದ್ದು 20 ಎಕರೆ 2 ಗುಂಟೆಯಲ್ಲಿ ಮಿಕ್ಕಿದ್ದಲ್ಲ ಅವ್ರಿಗೆ. ಹಾ, ಬರ್ಕೊಳ್ಳಿ. RSL. The parties have jointly filed a compromise petition under Order 23, Rule 3 of the Code of Civil Procedure. So, the first respondent, Sri M.S. Somegowda, I filed the suit. Invoice number 28 of 2008. Seeking declaration that he is the absolute owner, that he is the adopted son of Sri Siddappa, Srimati Siddhamma, and that he has succeeded to the property of Srimati Siddhamma, namely the suit schedule property bearing survey number 15 of Agasana Hundi village, measuring 20 acres and 2 guntas. So, the plaintiff had also sought for a permanent injunction restraining the defendant and all persons claiming under the defendants. The defendant number against the defendants from interference with the plaintiff's peaceful possession of the suit schedule property. So, the suit was partly decreed while only granting an order of permanent injunction while declining the relief of declaration. Declaration will stop. However, the first appellate court in RA number 425 of 2014 reversed the decision of the trial court insofar as the prayer for declaration is concerned, and declared that the plaintiff is the adopted son of Srimati Siddhamma, and that he inherited the suit schedule property from Srimati Siddhamma. So, questioning the same, the third defendant in the suit, Sri Shivannachari, filed this RSA. Stop. During the course of the proceedings, both Sri S.M. Somegowda, M.S. Somegowda, as well as Sri Shivannachari passed away, and the legal representatives have been brought on record. Stop. Next para. At the instance of the well-wishers, the parties, namely the original plaintiff through his legal heirs, legal representatives, and defendant number 3 through his legal representatives, have filed this compromise petition. Stop. The parties have agreed that the promote of 20 acres and 2 guntas of land of the suit schedule property, 1 acre and 28 guntas will now belong to the appellants here, for the legal representatives of the original defendant number 3, Sri Shivannachari. Will stop. The appellants have no objection for the revenue authorities to continue the name of Sri M.S. Somegoda or his legal representatives as the owners, absolute owners of the remaining extent of land, that is, as per the
18 acres.
18 acres, 14 guntas of land from out of the suit schedule property.
Schedule maintenance.
Schedule 1 and Schedule 2.
In fact, Schedule 1 to this compromise petition is the property allotted to the legal representatives of the appellant for original defendant number 3, and Schedule 2 is the property that will be retained by the legal representatives of respondent number 1 for original plaintiff.
Sketch is also attached.
Stop. A sketch showing the demarcation of the two properties is also filed along with the compromise petition. Stop. Next paragraph. All the parties are present before the court. This court has verified from the parties as to whether they have the knowledge of what is contained in the compromise petition. Stop. All of them have stated that they have understood what is contained in the compromise petition and they have no objection for the matter being decreed in terms of the compromise petition. Stop. Next paragraph. Accordingly, the RSA is partly allowed in terms of the compromise petition. Stop. The original suit is accordingly decreed in terms of the compromise petition. Stop. Next paragraph. Parties are directed to affix their signature to in the order sheet, while the learned counsel, respective learned counsel, will identify the signatures. Yes.
I'm not thinking. Name,
ತೊಂದ್ರೆ ಇಲ್ಲ.
The name it is Bhagya caste ID, but they signed it as a Bhagya.
ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸೆಂಟೆನ್ಸ್ ಸೇರಿಸ್ಕೊಂಡು ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ಬರ್ದಿದ್ದೀರಾ? ಹಾ.
Signature is
ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ the learned counsels have pointed out the office objections raised in the compromise petition that appellant number 1B, Srimati Bhagya, has affixed her signature in the compromise petition as Bhagyamma. Stop. The same is accepted. Huh? ಅದೇ ಬಂದಿದೆಯಲ್ಲ ಆಗ್ಲೇ ಹೇಳಿದ್ದೀನಲ್ಲ, ಐ ಹ್ಯಾವ್ ಸೆಡ್ ಸೊ. ಸ್ಕೆಚ್ ಹಸ್ ಬಿನ್ ಅಪೆಂಡೆಡ್ ಟು ದಿ ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ಅಂತ ಹೇಳಿದ್ದೀನಿ. ಎಸ್, ಈಗ ಅದ್ರ ಪ್ರಕಾರನೇ 11 sketches to be prepared and then produced before the authorities. Yes. Writ petition ಅಲ್ಲಿ This writ petition was filed by Shri M.S. Somegowda, who has since deceased, and the legal representatives have been brought on record. So, the writ petitioner was aggrieved of the order annexure E dated 6/5/2002, whereby the respondent deputy commissioner Mysore district had upheld the orders passed by the assistant commissioner. Huh? ಅವರೇ ಮಾಡಿದ್ದ ಆರ್ಡರ್.
The Kada was restored.
By the deputy commissioner.
He himself not character.
The petitioner was agreed of the order of annexure A dated annexure A dated 6/5/2002, whereby the deputy commissioner Mysore district
had set aside his earlier order dated
Dated 33/91.
33/1991. Full stop. The original order dated 33/1991 was passed by the deputy commissioner at the instance of the writ petitioner, who had sought for
Restoration.
a restoration of the khata while removing the endorsement of Phada on the land in question. Full stop. Although the deputy commissioner accepted the payment of tax and ordered the restoration of the khata while removing the endorsement of Phada at the instance of the writ petitioner, nevertheless, at the instance of Sri Shivannachari, the deputy commissioner passed the impugned order dated 6/5/2002, while holding that Sri M.S. Somegowda was not the adopted son of Srimati Siddhamma. ಕೂತ್ಕೊಳ್ಳಿ ಅವ್ರು ಕೂತ್ಕೊಳ್ಳಿ. ಸಿದ್ದಮ್ಮ ಏನು ಹೆಸರು?
He did not produce a budget.
All right. Stop. The writ petitioner, original writ petitioner C. M.S. Somegowda had earlier filed writ petition number 29369 of 2002, challenging the very same order dated 6/5/2002. Full stop. However, this court, ಎಲ್ಲಿದೆ ಅದು? By order dated 16th of August 2006, dismissed the writ petition as withdrawn, while reserving liberty to the petitioner to approach the civil court to work out his remedies. Stop. Accordingly, Sri M.S. Somegowda had filed OS number 28 of 2008. Stop. Sri Somegowda had sought for ಅದು ಇದರಲ್ಲಿ RSL ರೆಕಾರ್ಡ್ ಮಾಡಿದೀವಲ್ಲ, ಸೇಮ್ ಥಿಂಗ್ ಹೆಂಗಾಯ್ತು ಟಿಲ್ ದಿ ಆರ್ಡರ್ಸ್ ಫಾರ್ ಪಾಸ್ ಬೈ ದಿ ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್. ಹಾ
ಏನು?
ಆಯ್ತಾ, ಅದನ್ನ ಹಂಗೆ ಅದೇ ಮಾಡ್ಕೊಂಬಿಡಿ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರ. He said RSA filed by Sri Shivannachari was connected to this writ petition, and on this date the parties filed a compromise petition, and in terms of the compromise petition, RSA has been disposed of while directing the degree of the suit filed by Sri M.S. Somegowda in terms of the compromise petition. Full stop. The parties have agreed that from out of 20 acres and 2 guntas of land, the legal representatives of Sri Shivannachari will be entitled for 1 acre and 28 guntas of land, and the remaining 18 acres and 14 guntas of land will belong to the legal representatives of the petitioner, the original writ petitioner, Sri M.S. Somegowda. So, in that view of the matter, this writ petition is required to be disposed of in terms of the compromise petition. Compromise entered into between the parties in respect of the property in question. Full stop. Next para. Accordingly, the writ petition stands allowed while setting aside the impugned order dated 6/5/2002 passed by the second respondent deputy commissioner while restoring the khata in favor of Sri M.S. Somegowda. Full stop. Further, in terms of the decree that is passed in OS number so and so, in terms of the compromise petition, the legal representatives of Sri M.S. Somegowda may proceed to have their names entered in respect of 18 acres and 14 guntas of land from out of the property in question. Full stop. Similarly, respondents number 4 to 10. 10. ಹೌದಾ? 4 to 9 who are the legal aids of Sri Shivannachari will also be entitled to have their names entered in the land records in terms of the decree that would be drawn in OS number so and so, in terms of the compromise decree in respect of 1 acre and 28 guntas of land. We'll stop. Ordered accordingly.
Number 41.
ಎಲ್ಲಿ ಏಜಿ ಅವ್ರು ಇಲ್ವಾ? ಈಸ್ ಕಮಿಂಗ್. ಎಸ್. ಯಾರು ಉಳ್ಕೊಂಡಿರೋದು?
preliminary notification is of the year 2000. In 2022, there is not an. The investment time we developing this land, not development in the sense of real estate, in terms of agriculture. They don't want to agree for the settlement. They are not happy with the proposal. In fact, we have given a counter proposal.
See, you have been given something that is not given to the others.
No, I am told that it is being given. to
Beyond that, it's not possible.
the-
Anyway,
No, I am only
it is
saying
up to
that-
them.
No,
Now,
I am only saying why they are not agreeing.
all right.
Because
All
they
right.
feel that they have a good case, they have a good chance because of the delay that has occurred.
Hmm.
Then I had, on the last-
Learned Council for the petitioners has filed a memo dated 10/1/2024. WP number 16422 ಅಲ್ಲಿ. Huh?
one problem.
Stating that petitioner number 11, Shri Anil Kumar, son of Narayana Swamappa, seeks leave of this court to withdraw the writ petition. While accepting the offer. Yeah, while
They are directly talking.
they have already
They are
taken.
directly in touch with
Withdraw the writ petition. Stop. As per the memo is taken on record, subject to all just exceptions. Stop. Accordingly, the writ petition stands dismissed insofar as petition number 11 is concerned. Yes. Yes.
recall that the earlier instance I had stated that originally this the policy the central government had issued notification for IDIR and subsequently Union of India before the Honorable Court has submitted that proposal is withdrawn. Final notification is subsequent to that's what not just on facts, a few submissions, but I will only give the dates on which the notification is issued.
9/6/2010.
9/6/2010, page 188.
Ah.
Next step.
For an extent of 2072 acres, 24 guntas. Yes. Then 25/5/2022, final notification for 867 acres, 37 guntas. Yes. Then again, one more notification. What is this 19/6/2023? All right, really. All right, yes.
But I have arranged 28/1 as well as 28/4. I have also pressed the ground of delay in issuing. Also, I have challenged they have specifically raised an objection saying that I have not challenged the order passed under 28. I have filed a application seeking for amendment 28/4. I had here filed the petition challenging 28/1 and 28/4. I have filed an amendment petition also to add. Not now they permitted to take on sense that we rise for your lordship's consideration. But in a similar matter, the somebody for
Similar questions were considered. We refer to those questions that were considered.
Yes.
And the points that we in support of. But what should we get the point that was considered in at page 11 in the first judgment?
Hmm.
Page 11.
Hmm.
Whether the consideration of petitioner's objections by special land acquisition officer is satisfactory. Whether the government has applied its right to section 28(3) order and the objections filed by the petitioner before issuing final notification in the section 28(4) of the AIA Act. Whether the acquisition of land in question suffers from myself discrimination. While considering the first question, at para 23, the learned citizens of the Honorable Court, referring to AIR 1972 SC 591. The words considers it necessary postulate that the authority concerned has thought about the matter deliberately and with care, and it has been found necessary as a result of which of such thinking to pass the order. The dictionary meaning of the word consider is to view, take the view, to survey, examine, inspect, to look, take the view, to contemplate mentally, to think over, meditate on, give heed to, take note of, to think deliberately, bethink oneself, to reflect. My submission is the passing the order in the 28(3). No, the land acquisition not applied.
What was your objection? What was your
My
objection?
objection was that the land is required, that is, the petitioner's family is relying on that particular land. We have constructed farm buildings, grapes, farm buildings, farmhouse.
Farmhouses.
Yes. Grapes are being grown, they are all, the family is dependent on, this is the gist of the statement of objections. My lord, may I kindly turn to paragraph 56, at page 13 of the same judgment. At page 13. Section 28(3) order is not reflective of the consideration of petitioner's objections. Mere mechanical or stereotyped rejection of objections cannot be regarded as adequate. The recording of reasons ensures that the SLAO has applied his mind to the case and the reasons which impelled him to take the decision in question is germane to the content and scope of the powers vested in him. I therefore answer question number 1 by holding that SLAO's consideration of the petitioner's objections is not satisfactory. It may not be necessary for SLAO to write out a judgment as the court of law does. However, he must at least state what arguments are canvassed and for what reasons he is rejecting them. Now, may I request your lordship to kindly turn to page 19. I have relied on one more judgment of division bench of this honorable court. At page 19. But the gist of what the reasoning given by the land acquisition officer, I have just extracted. Can you see the judgment of the division bench of this honorable court? At page 19, para 4. Learned counsel for the appellant submitted that the order passed by the board is a detailed and speaking order, and therefore
The learned single judge grossly interfering with the inquiry. We have considered the submissions made by the learned counsel for appellant and have produced the record. The relevant extract of the order passed by the special land acquisition officer of the board reads as under. Your lordship sees the right hand side column. Third objection. Under the spot inspection, the said land is found to be required for industrial area and suitable price has been fixed to trees crops standing in the land and hence the objection refused and order for acquisition. Thus, it is evident that no reasons have been assigned by the special land acquisition officer for rejecting the objections preferred by respondent number one. The order only contains the confusion and has been passed in a specific and familiar manner. The learned single judge has therefore rightly felt that the order is non-speaking and cryptic. The learned single judge, therefore, in the facts and circumstances case, has rightly limited the matter to consider objections referred by respondent number one and to pass fresh order in accordance with law laid down by the division bench of the Honorable Court in H.M. the State of Karnataka, judgment dated so and so. Now, my lord, if your lordship sees, it is exactly the same words. There is no application of mind while passing this order. If your lordship sees, it is of course the translation of what is written by the land acquisition officer. The gist of it is undertook inspection, considered objection, since said land is found to be required.
Yes, yes.
Said land is found to be required for proposed industrial area. The objection is rejected and ordered for acquisition. The RTC is in the name of so and so. Same. Next one also is the same reasoning. Your lordship sees on the order that is passed in respect of each land, the same reason. I mean, it is no reason. Is my respectful submission. Therefore, 28(3) order has to go by virtue of the judgment of the division bench passed by this honorable. My lord, that apart. Coming back to the first judgment, my lord, that I relied on the second question. Page 30. Page 30. Judgments that I have given.
13 or 30 now?
Para 28. In the case of command reading, the final notification has to be issued until after the government is satisfied on considering of section 5A report, section 28 in the order in these cases. It is reiterated in the said decision that the government, while issuing the final notification, is required to apply its mind not only to the objections filed by the owner of the land in question, but also to the report which is submitted by the collector SLAO and also the recommendations made by him in that regard. Mere note acceptance or endorsement of the SLAO order by the government does not meet the requirements of law. Now, based on the SLAO's order, the 28(4) notification has been issued. Therefore, I have kindly turn to the next page at para 30. As section 28(3) order is not a recent order, and in the absence of the application of mind on the part of the government, the objections filed by the petitioner, constitutional section 28(4) final notification becomes unsupportable. As the government is in no position to produce the file containing the approval for issuance of section 28 for notification, it is well nigh impossible to know whether the government has applied its mind to the SLA order, to the petitioner's objections, etc. There is no way of knowing whether the approval is accorded for issuance of 28 for notification. The court has to only draw the necessary inference from the stated displacement and consequently its non-production. Therefore, answer the second question in the negative. In the result, I hold that the notification issued under section 28 of the KIA Act is liable to be filed. Now, my lord, the acquisition of land also suffers from rise of discrimination. As we have seen from the preliminary notification, 2017, in fact, originally as per the scheme, 10,500 acres was the proposal, out of which preliminary notification was with respect to 2,072 acres, and final notification is with respect to 867 acres. There is no mention in the there is no reason, there is no mention in the statement of objection as to why so much of land has been left out. Look, my other submission case, so far as the notification issued under 28(1) is concerned, because section 28(4) there is a delay, and 28(4) notification is issued beyond a reasonable time. The 28(1) notification that is issued also must take. That is why I am relying on the judgment of this honorable court. That is at page. It starts at page 37. With respect of Karnataka Improvement Boards Act, but even there, no limitation. For argument's sake, they may contend that no limitation is prescribed in the Act. But similar argument was addressed in this case also. In the honorable, this honorable court relied on the
In respect of the very same provisions of the KAD Act, subsequently there have been judgments of the Supreme Court itself. You are going back too far.
Reasonable in this case, what is reasonable? 3 years is considered as unreasonable. In my case, there is nearly 12 years of delay in issuing the final notification. Lord, may kindly take page 45. Relying on this particular judgment, the facts are similar, and this based on reliance on the judgment of the Honorable Supreme Court. These appeals will have to pay on one more ground. We believe that there are 6 orders.
Yes.
Page 45. That's 16. These appeals will have to pay on one more ground. A preliminary notification was issued on 22/1/1985 and published on 7/11/1985. Navile village itself was included within the urban area only in professional highway 1987. The development scheme was approved by the state government under section 18 of the Urban Development Authority Act on 15/3/1989. The final notification was issued more than 3 years thereafter on 2/6/1992. The time gap between the preliminary notification and final notification is as much as 7 years. Even if the period up to the approval of the scheme by the state government, I said 3 years, it is 7 years. Up to the approval of the scheme by the state government is excluded, there is a delay of 2 years. It is no doubt true that neither Karnataka Improvement Boards Act 1966 nor Karnataka Urban Development Authority Act 1988 prescribed the time limit for issuing publication of a final notification under section 19(1). The effect of delay has been considered by the Supreme Court in Ramchandra versus Union of India. Though the said case dealt with the delay between the date of final notification and the date of passing the award, the principles enunciated therein will equally apply in respect of the delay between preliminary notification and final notification. The following observations are opposing. It is well said that in a statute where for exercise of power no time is fixed, it has to be exercised within a time which can be held to be reasonable. The authorities are enjoined by the statute concerned to perform their duties within a reasonable time, and as such, they are answerable to the court. Why such duties have not been performed by them, which has caused injury to the claimants. The Supreme Court held that where the inordinate is a fraction of the market rate prevailing at the time of passing of the award and would be unjust to the landowners. In this case, authority has not explained the inordinate delay, even if it is assumed that the delay up to 53/1989 is explained by reason of the fact that scheme was approved by the government and the Section 18 of Act on that day. There is absolutely no reason forthcoming for the delay for more than 3 years between 1989 and 26/1992. In this case, the landowners have approached this court in the year 1992, immediately after final notification, and are having the benefit of stay. In the circumstances, even if preliminary notification is held to be valid for any reason, the final declaration under Section 19(1) of the Act may have to be held to be invalid on the ground of delay in issuing the same. Be that as it may, as we have held that Shimoga Improvement Board had no jurisdiction to issue notification under Section 15(1). Final notification. My respectful submission is therefore both preliminary notification and final notification. We are also enjoying the benefit of stay in these proceedings. We have also challenged the notifications immediately after the final notification. Therefore, these judgments happily apply to the case on.
ಕೊಡಿ ಅದಕ್ಕೆ ಫೈಲ್ ಕೊಡ್ರಿ. You are only representing. Hmm. One and two are not with you. Huh? Yes, sir.
I don't know the arguments. We have recently submitted for each What are the conditions? Out of which the petitioners are into agriculture or horticulture and tomatoes and vegetables, and there are certain things which are important to the artisan. And certain artisans also represent where there are open wells, bore wells, and what are the trees or what are cultivation regarding the artisan system. In the RTCs, the assessment
That is why they have taken NOC. They should have in fact filed a memo seeking to withdraw the petition, as was done in the case of others. Anyway, it's all right, doesn't matter. All right, all right. But you have information that they have received.
what is the Kandaya they're paying on the land.
Hmm.
So where there is a question objection to raised by the from saying that this that answer here the assessment is up to 6.94 till 8 assessment has been mentioned on the parking system. By this we'll understand that what is the fertility of the land. And along with that, I would like to rely on judgment. Order passed in 2013. I think there certain fertile matters are there. Page number 20. Page number 21. In case the honorable has laid on this article text for judgment, Raghuveer Singh Sahara versus State of Haryana. Page number 21. Page number 21. Paragraph 42. The apex code. It is difficult, if not impossible, to appropriate as to why the state and its instrumental means to match it administration of land and without complying with the mandate of the statute. As noted by the National Commission of the Farmers, the acquisition of agricultural land in the name of land development or industrial growth would seriously affect the availability of the food in future. After independence, the administrative apparatus of the state has not spent enough investment in the rural areas and have been doing adopt alternative sources of revenue. If land of such sources is acquired, not only the current but the future generations are doomed. This is one of the reasons why the farmers who are deprived of their holdings comes to. In this matter, by deciding the questions considered three questions. I would also rely on the second next page number 22. Questions whether the petitioner's objections are considered, whether the hearing exercise is satisfactory, whether the final notification issued under section 28 of KIDP Act is valid.
Yes.
So section 28, clause 3. It says, after considering the cost, I'm reading the last part of the same.
The same thing, that same contention.
Certain one of I'll avoid
All.
after considering or any shown by the owners of the land and by any other person interested therein, and after giving such owner and the person opportunity of being heard, not being heard, and the state government may pass such orders as it is. But here the word needs to be considered as being heard and considered. Continuation, my version of section 28B, orders shows that the land acquisition officer has just referred the objection filed by the petitioner, they referred the objections filed by the petitioners, but he has not considered them. The reasons given by him for rejecting the objection are acquisition leads with the best intention, the acquisition is a interest. The council has read the orders which is passed with the translated in English. And just read just one line in Kannada, what they have exactly written. ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿದೆ ಆಕ್ಷೇಪಣೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು ಈ ಜಮೀನು ಉದ್ದೇಶಿತ ಕೈಗಾರಿಕಾ ಪ್ರದೇಶದ ಯೋಜನೆಗಾಗಿ ಅತ್ಯವಶ್ಯಕವಾಗಿ ಬೇಕಾಗಿರುವುದರಿಂದ ಭೂಸ್ವಾಧೀನಕ್ಕೆ ಇರುವ ಆಕ್ಷೇಪಣೆಯನ್ನು ತಿರಸ್ಕರಿಸಿ ಭೂಸ್ವಾಧೀನ ಮಾಡಿಸಲಾಗಿದೆ ಆದೇಶ ಹೊರಡಿಸಲಾಗಿದೆ. They have not even mentioned the reason why, what is the ಪರಿಶೀಲನೆ, not they have used the word ಪರಿಶೀಲನೆ. Petitioner number 5, I'll just in 2 minutes, I'll just tell what are the lands are holding in petition. Petitioner number 5, they are building horticulture, farmhouse. This person have been taken, he got some 4 or 5 acres of land. Now remaining is 1 acre. In that he got a house, he had children to take care of it. Other than this one house, here is nothing to do. Petitioner number 9, petitioner number 9, Anumanta got 40-year-old, 2,000 acres, 2,000 acres, 8-year-old sandalwoods, n number of trees in petitioner number 9. And petitioner number 10, 11, 12, they have 1,600 areca plantation there. And 2 borewells with the farmhouse. And petitioner number 13, they got 2 borewells, washing house and the plantations. Coconut tree, vegetable, horticulture, electricity, almost all petitions for electricity, farmhouse and the borewell. But these are the petitions, they are not objecting to entire acquisitions they have made. I have made a submission and this submitted the petitions last year when there was a matter of compromise. How much land has been already acquired and they are not having considered. Now, putting the prayer before the honorable purpose, maybe 1 acre, half an acre, 2 acres, which are remained where the houses are, which are adjacent to the villages. Then requesting this honorable to consider, we have already given up for 8 to 10 acres of land, and we are just requesting for 1 acre, where our house is there. Or if they will office has given the response has been given by not only the petitioners,
How can it be left out like that in pockets? It is the ruling of the Honorable Supreme Court that this kind of islands cannot be left out. Then?
Where the wall, beside the wall of the house, the acquisition has been taken. Especially in petition number 21, where there is a petitioners from Samadhi Kingdom. And they have 2 farmhouse, 250 coconut trees, 50 teakwood, and 50 silver room, and n number of trees are there. But I'll come back to the judgment where I'm going to. Here, they say of the consideration. But while making the objection, everybody have filed objections to issue the notifications and the notice of which they have received. In that, they have clearly mentioned what are there in the land.
So therefore, if you have brought all this to the notice of the SLAO, is there any law which says, no, if this kind of development has happened, it should not be acquired? No, your agricultural development I am talking of. The agricultural development that you are talking of, if that has happened, it should not be acquired.
These are the lands.
Yes.
I'm speaking of the provincial and model line.
Yes.
In my question, they have
No,
not-
therefore, that is the question that is coming from the court. No doubt you have brought all this to the notice of the SLA. If he has noticed this, what should be his answer? No, please tell us what should be the answer. It is not permissible for the SLAO to just give out all this kind of lands only because such developments have happened on the land. So therefore, even if you have brought this to the notice of the SLAO, what is it that the SLAO can do?
These are- there are something mentioned that there is a element of land has to be while making the final notification.
If any land, please understand, if any land has been left out inside within this 300 and odd acres, you please point out. That is why we are saying the latest judgment of the Honorable Supreme Court is that these kind of objections that would cause impairment in the development of the land should not be considered. If on the other hand, if they have left out pockets of land on some ground or the other, you please point out, we will definitely consider.
This taxes, where is the section? They have not acquired that seed.
Which one? Means villages,
Yes,
the Gramtana portion of it. That is village settlement means with that only.
where it has to be. And even in the market, two lands.
That is because it's a village settlement. Yes.
Page number 20, paragraph 12.
Yes.
And read from the last 6 to 9. Consider where the word is unconsidered. Consider means to think with care. It is also mentioned that to consider is to fix the mind upon with a view to careful examination, to ponder, study, meditate upon, think or reflect with care. It is therefore manifest that careful thinking or a due application of the mind regarding the necessary complete examine the document in question. It's time for non further making of the order is essential for making the order. If the impugned order is there to show that there has been no careful thinking or proper application of the mind as per the necessity of operating examining the specific order, the essential requisite to make the order can do be non-existent. Also rely on the same judgment in the paragraph 14. So, it is neither possible nor desirable to make a list of the grounds on which the landowner can pursue the collector to make recommendations against the proposed acquisition of the land. But which is important is that the collector should give a fair opportunity of hearing the objection. Objectively consider his plea against the acquisition of the land. Only thereafter he should make a recommendation supported by real people as to why the particular piece of land should or should not be acquired and whether or not be followed by the objector merits acceptance. In other words, the recommendations made by the collector must reflect the objective application of the mind to the objections filed by the landowners and the other interested persons. Page number 27. Page number 27. Science book, page number 27. Paragraph 15. So, paragraph 15. The rejection of the petitioner's objections for the reason that the acquisition is a public interest or that it is done with the best intention or the not upon the their objections. Technically and stereotype reasons cannot be regarded as adequate. The recording of the reasons ensures that the SLA applies its mind to the case and the reasons that impel him to make the decisions in question, take the decision in question. The first question is answered accordingly, where there is a consideration whether they have considered the objections filed by the petitioner. Paragraph number 68 has this very important thing. As far as the exercise of hearing is concerned, it is not in dispute that all the objections were heard on 5/7/2007 and 8/5/2007. It's usually not possible to hear hundreds of objections in 2 days' time. Even a professional judge may find it difficult to complete the hearing exercise in respect to the hundreds of objections. Section 28 of Clause 3 of KIDB Act embodies states just and holds a principle that the person whose property is intended to acquire should have the option to pursue the concerned authorities, not the acquire his property. Putting an opportunity of being heard is with a definite purpose and cannot be reduced to an empty formality. In my case, also there have been heard thousands of hearing in a one of the cases, where option is given to the parties whether you say yes or no. They even have not cross-checked whether the person who is saying yes or no is aware of the property or not. Last one was like to mention, paragraph number 18. At the very outset, to answer the third question, what can be said in the unreasoned order under section 28(3) of KIDB Act would be wrong for the government to take a final call on the issuance of the final notification under section 28 of clause 4 of KIDB. When section 28(3) order itself is listed, section 28 of clause 4 notification becomes unsustainable. There is a deficiency while passing the orders in 28 of clause 3. Consideration of the objections has not been taken. Hearing of an opportunity has not been afforded to the petitioners. In this case, where the early years of delay in issuing a final notification and refuse responsible to crush the order by primary and preliminary and final notification. And along with that, I also have challenged the order 28 of the history. I have also filed the amendment.
Yes.
23, detailed order has that we have produced along with the memo on 5/8/2023.
In both the matters?
Total extent was 867. With respect to
When was it filed?
56.
Hmm.
We will order the support whole 860 something. Not particularly in the qualification. These are the survey numbers. They are finding and detailed and we have given at the bottom. At the end of the 23 order.
Not in respect of each survey number. Yes.
In addition to that, at the bottom number, we have considered all the objections. In addition to that, matter, half of them have not appeared before the SLO. They have not filed objection. That also one earlier from having submitted members. Where it goes to show that they have not bothered to appear before, in spite of repeated notices, they don't appear before the SLO. And they don't even file an objection. And all of them filed clear objections, identical. No documents have been produced to show that 200 trees were there, 400 trees. Even if it is there, they are entitled for monthly one. If the houses are there, they are entitled for monthly for those houses and the trees. Then, I have also filed my affidavit. It is a total extent of 867 acres of land. Now, almost 467 people have taken compensation. 20 acres have taken Denmark area. I have also filed a recent affidavit after that one more person have taken compensation. Now, under that, the sketch. It was it was 516, hard.
Yes.
That's page number 4. The India minus the city Foxconn is stating with respect to that Foxconn, which is taken 300 acres of land. In that, my lords, at serial page number 4, these are the lands which comes in that area. My lords, out of that, serial number 1 has taken compensation, my lords. And he has withdrawn that, he is not taking compensation, he is taking the developed area. He has withdrawn that case. Then left with 8 acres, 38 kuntal. That the sketch I have produced at page, the last of the affidavit. Notes. Then my lord, we kindly for you that sketch at the bottom. Produced. The sketch on my application of only application about a portion of land in the Foxconn, which they are showing you. They have filed it with respect to both the cases. It is not only with. No, I will explain this. It's just be complete. I didn't know anything. You see that the orange border I have made. The orange border is just 300 acres of land. Then minus the investment of 21,000 crores are made by this particular company, and they are generating 1 lakh employment. We also offered them employment. If they use the land, we offer them employment. That offer also helping. Colors this land on red color area is before this honorable court melons. Out of that, the middle red color has taken developed area and he has withdrawn to developments. Other than that, in 867 acres, these are the lands which are highlighted in green, are the ones who are before this honorable court melons.
Green.
Green ones. Green ones is outside the Foxconn area, but in the acquisition acquired area melons. These are before this honorable out of total 110 people who 110 acres were challenged this. Now we are left with only 50 acres. Given the tendency of the trees, most of them have come and we have given 467.
There is only one patch of green. One patch of green in between this Foxconn area. There is one green patch at the bottom.
Yes, there is a green patch.
What is that?
That should have been red. Should have been red. Some other.
Okay.
And other than that, entire area 867, there's everybody has taken a compensation. What developed area belongs. And it's not that it's that they have not the areas are adjacent on the side, nothing. No objection whatsoever has been filed, not against people that and it has been softly challenged now at this stage. When after my objections are filed, they are then after the challenge and my lords, the permitted to rely upon the evidence of this honorable court, which was passed in the Sharda's case.
Yes.
That's the court judgment. has submitted that we have not appeared and we have not filed objections. We have filed the petitioners along with the documents, what objection has been filed, you can see, and the orders which they have passed, they themselves have recorded that the so party has been presented and says that objection is there. Okay. The judgment of 22nd September 2023 of this honorable court member, when identical issue has been arisen with respect to delay and with respect to the fertile land, respect to the fertile land. This one will be considered in the notification of 2030. I have the opinion that if the lands come within the, it is not a matter of in an landed, then it cannot be left. It's the finding based on the notification which has been issued by the government of Karnataka. Therefore, the objection with respect to that does not survive. And with respect to the first delay also has been addressed, my lord, in this particular judgment. In this case, my lord, the extent was huge. We had to, if we had to acquire this, given it to an industry, there should be a connectivity. So we were in the process of acquiring other land which connects to the NHL. So therefore, my lord, that acquisition proceeding also has been initiated. And we are acquiring 180 acres so that we can connect this particular piece of land to that to the national highway. And there are huge extent, my lord, 2,000 acres of land. So in that process, it took some time for us to issue the final notification. It's my submission so far as is concerned. And then there was other aspects, my lords, the judgment of this honorable court of 22nd September 2023 encompasses all the other judgments. With respect to the delay, with respect to the acquisition of fertile land, those judgments also are along with my judgment compilation. We have given them 10,781 square feet developed area in lieu of per acre. Total 20 acres have been already given developed area to the people who have asked for it. Then, my lords, we have also given them that in the immediate sale deed will be executed. And if they want to purchase any land out of this compensation, no registration fee will be exempted. There are so many benefits that we have extended in that case, and they are also entitled the differences with respect to market land and the trees in the address, because we are giving compensation by inspecting the area. That is not something which we are telling them.
Where have you put this information that regarding the other benefits that were offered? Where is it?
They have given we have given the
No, but you have not placed it on record. Where is that, I must? Where is that?
in 164.
No, if you have already placed it on record, if you please tell me,
Notifications also that they are based on what notification we are giving them. But the date on that.
please pass on the information as to information to the court. Which petition? Yes.
Both the matters they have given a proposal in writing, we have given a counter proposal in 5 days.
All right.
We are taking very different. Senior is already a good party. Okay. We'll finish documents on that.
No further date. That 19/6/2023 is it? Your notification.
Hello, as I was telling you, the 180 meters we are required for NHI. So to connect it with the NHI, this is the precedent. In this, we have issued the preliminary notification on 18/3/2022 and final notification we have issued it on 17/2022.
There is no delay then.
Plus our grounds are not divided.
Hmm.
We have a different grounds.
Hmm.
Still, Melas is just. What date?
Because they have taken benefit of these stay orders, got it connected, different notification methods. Same within 1 year we have passed final order. There is no error in the order which has been passed. And when they are taking shelter of that, it takes.
Plus they are only for a brief time, no substitution. No petitions for. You also feel that they don't have their united. We could get back to you on that. So
This is what is transpiring.
get back to you on that.
They were fully aware that this is what is going on. And this is a different notification altogether for that road. And it was 18/3/2022 was the preliminary notification. And final notification was passed on 7/3/2023. They have filed objections to the petition number 1 filed objection, my lords. And petition number 2 did not even file objection.
But now the third writ petition. This is regarding that other extent of land. That this writ petition pertains to that acquisition. He is saying, please have it next week.
We issued the final notification within 1 year.
There.
That's the clear.
Allah, that ground also is not there. But he is also saying, we will consult and since a few more petitioners have withdrawn, we may also withdraw this. So please give us a week's time ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ.
Complete other two matters. Separate it and have it.
What do you say? We will have it next week. Only for the benefit of that writ petition. In the meanwhile, if there is any change of mind, you can also let us know. Otherwise, we'll proceed to pass out. There. Even before when they started the argument, I have said I have passed orders recently on all these contentions. I have been telling again and again that recently I passed a judgment considering all these type of objections.
There is an out of the Oxford with the area something 60-40. I mean, this is nothing, the value is cannot be.
Allah, see, some of the petitioners have understood. They have withdrawn. A few of them are there. We can't force them too much.
It's actually a gold mine, over there. No land is available. I'm giving, I mean, percentage losses, increase whatever. In fact, they do not understand today. Instead of going for compensation.
No, a submission also made by the learned counsel that this special benefit they are now proposing is available only to these. Then the learned counsel said, no, it was given to others also. I don't know how that is possible.
All 80% is consent award.
Adene.
And possession taken.
That consent will only be according to that consent given that point of time.
And one more thing.
I don't think that.
As landowner, they should be happy if others also given, if subsequently they will give others also. They should not be happy that landowners are not getting. Land ownership, that one more landowner is also getting.
No.
So this is special benefit.
Sir, I don't know how, if that kind of a benefit is now proposed, it is also given to the others. I don't think it is possible.
That must be, that I verified, we had a couple of meetings, we pushed them to give this, to give us quite.
Already, purple. I thought we will have it next week. We will have it next week. I, otherwise it is like. Yes. No, because that kind of an observation has been there in the other subsequent judgments of the Honorable Supreme Court. See, you can't expect the SLAO to give special reasons for every objection. If the objections are similar, his reply also should be similar.
Are not similar. That is what.
In the end, difference, please tell me, what is that great difference that you are trying to point out? Other than saying, no, it is a developed land, we have a farmhouse, this is the only land that is left with us. Other than these objections, can there be any special objection that you have raised?
Consider, because court cannot sit and do that exercise if the SLO does not do. That is why the courts have repeatedly said that no, you have to consider these objections and you can't pass an order in a cavalier and a fictive manner. The reason for saying that is courts cannot sit with every objection and compare it and say, yes, you are not considered this, you are considered.
All right.
No, that's the whole, that's my answer to what.
Sir, that is why the Honorable Supreme Court also, see, of late there has been a change in the manner in which the courts have to look into this kind of acquisition proceedings. Now, we earlier, by taking this kind of a stand, we have enabled small islands to exist in developed layouts. By accepting this kind of an argument, if the notification is set aside only in respect of one or two landowners, will it not create a small pocket in the entire layout? Would it be permissible, especially in an industrial area like this? I can understand if it is a residential area.
This is 300 acres plus another additional acre for one single company who give 1 lakh employment.
Is it possible to leave a small island now by accepting your submissions? Yes. No, ultimately that is what is going to happen if we accept your argument. If we accept your argument and say, no, this has not been complied, so therefore we will set aside the notification only in respect of this person, what will happen? Anyway, we have said what. See, the entire, the entire, correct.
That's the due process of law.
Compulsory acquisition, the powers of the government, that kind of a power they have.
Yeah, but they are not unfair.
Therefore, we have to take the totality into consideration. Why all these procedures? Only to ensure that there is a fair deal to the owners of the land. There is equal compensation given to them, the best fair compensation given to them. There cannot be anything that can come from the court saying, no, you are not followed the procedure, so we will leave out this land. From ang manak barodilla.
They are all on their own. It is like a self-employment for an agriculture. Employment offer security guard, some driver,
Adbidi, adbeda.
It is not security guard like that.
Someone who is qualified does not want to do agriculture, will do agriculture.
That is why with the amount, the money that you are getting, if you really want to do agriculture further, you take some other land. It need not be very near to the city.
Only for the sake of.
Not that you should not do agriculture, it should be the prime consideration. If people are ready, yes, people are ready and willing to do agriculture even now, they should be encouraged. Adre, we all know what is happening in and around Bangalore. The entire problem is there. None of them are doing agriculture, except a few pockets. It may be a genuine case in your case, but then just because you have really put it to use as an agricultural land, can it be left out of acquisition? If there is any development made, like 2000 teak trees, they have value, they will be valued and you'll be getting compensation for that. Anyway,
This is about the catchment area. All these objections are also taken. There is no answer to all this.
see, in fact, in the case that was referred, where I had passed the judgment recently, they had also relied on a circular issued by the KADB, by the state government, that agricultural lands should be left out of acquisition. Then it was subsequently clarified, having noticed that if that kind of a circular is issued and it is put to practice, then there will be islands or pockets left out within the industrial area, just because they are actual agricultural lands which have been developed as agricultural lands. So there they said, but if it is within the larger area and it is going to create islands, it cannot be considered.
In the material policy that was quoted, they have specifically said to look for non-agricultural lands. In spite of that, the preliminary notice.
ಅದೇ ಅವರು ಆತರ ಇಶ್ಯೂ ಮಾಡಿದ್ರು ಸರ್ಕ್ಯುಲರ್, ಬಟ್ ದೆನ್ ಇಟ್ ವಾಸ್ ಫೌಂಡ್ ಇಟ್ ಕೆನಾಟ್ ಬಿ ಇಂಪ್ಲಿಮೆಂಟೆಡ್. ನಾನ್ ಅಗ್ರಿಕಲ್ಚರಲ್ ಲ್ಯಾಂಡ್ಗಳು ಅಷ್ಟೊಂದು ಎಲ್ಲಿ ಸಿಗುತ್ತೆ? Impossible. It is impossible. Only people who really want to develop into some other industry or something would have got it converted, and they are not going to give it up.
They set a legitimate expectation in the minds of the people. And when that expectation is not met, they have to knock the doors.
Heard. Now, learned counsels for the petitioners in WP number 3667 of 2023 and 16422 of 2022. Stop. However, learned counsel for the petitioner in WP number 12961 of 2023 seeks for a short accommodation. Stop. Release this matter on 18th. 18th of January 2024 at 2:30 p.m. I will not say anything regarding the other things. You please make use of the opportunity, and if there is anything possible, you please let us know. Yes. For further hearing.
Nine acres are concerned out of course, 8 acres are concerned out of total. Comes right in the middle of this project. This is here, this one portion 9 acres. If you want to may not be withdrawn,
petitioner.
So therefore,
And the rest of it, adjacent land. Only
He
8
has
acres.
been approached and told that yes.
No, because they are trying to, approach 22,000 crores is the interest.
ಅಲ್ಲ ಇವತ್ತು ನೀವು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದು ವಿಡ್ರಾ ಮಾಡಿದ್ದು ಪೆಟಿಷನ್ ನಂಬರ್ 11. It has been dismissed.
So apart from that, there are these 3 areas of 8 acres which come part of the project only for the rest of it, only this 8 acres is also been not extended, the rest of it. Because part, just this 8 acres, so you have to extend the rest of it, because the initially 22,000 crores is getting delayed, other than.
No, see today some of them have already.
1 acre 25 gutas they have withdrawn.
Ah.
Survey number 6 for 5, petition number 11. What is the remaining is only petition number 12.
No, in their case, petitioner number 1 and 2 have already.
It's a long time back.
Yeah.
After
May I make this?
just only 6 so that you know.
In the event I succeed.
No, I will write.
Therefore, I respect.
ಯಾಕೆ ಬೇಡ ಇನ್ನು ಒಂದು ವಾರ ಟೈಮ್ ಇದೆಯಲ್ಲ ಬೇಡ ಲೆಟ್ ಇಸ್ interim order granted earlier stands extended till next year.
Even though they did not take part of the time, you need to say.
Yes.
So I not completed that the entry order not extended, so I.
All right. No, it's all. ಯಾವುದು serial number 42. Next matter. Final hearing. All other matters next week.
48. Serial number 48, opposition defense property. Asking to allow your 648.
E group
48.
48.
Defense over they are short for time last week.
Action of very officer, but two unknown parties entered into a compromise before they made a they compromise in the respect of defense land, and the rest of the compromise getting not the revenue in the country. I have question needs to be heard. The lordship assigned to be.
Serial number 48. Released this matter on 17th of January. Sir.